Hello?
Sir, would you identify yourself on the Motorola G Pure?
David George.
All right, Mr. George, you're set for 9 o'clock. I'm gonna have you mute yourself. We're in the middle of a hearing, all right?
Okay.
I'm sorry for interrupting, Your Honor. I can't hear anything. I don't know if it's just my audio.
I'm on mute, Mr. Levine. So
I'm sorry, Your Honor. Okay.
all right, so we're in a hearing right now. So
Okay.
this is set for 8:30. It is now 8:49. It would appear that Ms. Williams has failed to appear with the documentation for the last, and this goes back to February 22nd. So I appreciate your attention, your patience. I'm going to deny her motion to set aside the order. Defendants failed to appear. I'm going to deny her motion to set aside order.
Yeah, I appreciate that, Your Honor.
Mr. Levine, we're in a different hearing right now.
Oh, okay. I thought it was Tiffany Williams and Ahmad Asaf. My apologies.
Yeah. It is. Oh, you're here for Mr. Asaf? All right.
That's correct, Your Honor.
All right.
Yeah.
I don't have an appearance, so I didn't know.
Yeah, no, it was one of those last minute sign-ons.
All right. So I'm going to deny the motion to set aside the order, and then there's an escrow of $256, and I'm going to indicate that that should go to the landlord, to Mr. Asaf in this matter. So any escrow payment should go to, depending on which side filed what, but I'm going to indicate plaintiff Asaf.
Understood. I appreciate it, Your Honor. Again, thank you.
All right. Thank you, Mr. Levine.
Thank you,
Mr. Asaf, thank you for your patience. You're all set today. Okay. Thank you. So we're that's all for the record. Docket 22-03928. And then Ms. Winters, you're here for 21-02605. Is that correct?
That's correct, Your Honor.
All right. So I do have an interpreter here, and I do have Mr. Mukata. Is that correct? Why don't both of you come up here? So I'll swear the interpreter in. Please raise your right hand. First of all, let's have you, sir, let's have you state and spell your last name for the record.
My first name is Abdallah, Abdalla. Last name Mukoma.
All right. Do you solemnly swear or affirm that you will make a true and understandable interpretation to the witness in the court, and that you will accurately interpret the statements made by the witness to the court to the best of your ability?
Yes, Your Honor.
All right. Thank you. So I will once again call the case for the record and then allow you to interpret. So we're on the record in docket 21-02605.
Kwa docket ya 21-0506.
That is Pioneer Mutual Insurance versus Walinga Mukata.
Sema kwamba ni Pioneer Mutual Insurance na Walinga Mukata, wao ndio wanapigana kusambiana.
And sir, you are Mukata Walinga?
Wewe unaitwa Mukata Walinga? Ndio. Yes.
Okay. And Ms. Winters, your appearance for the record?
Mwenye kuulizwa alongee.
Your Honor, Susan Winters appearing on behalf of the plaintiff, Pioneer Insurance.
Jina anaitwa Ms. Winter, kwamba ni yeye amesimamia mwenye alipigwa.
All right, this is the time set for, it appears this was initially set as a motion to set aside the payments and a request for hearing.
Asema kwamba ni hii ilikuwa kwamba ni kwa kuonyesha zile pesa kwamba ni ziko namna gani, alafu tumetafuta kwamba nikiwasikie alitokea nini.
It appeared that on March 16th of 2022, there was a fail to appear, and the motion was denied. I think that's by Judge DeLuca, but I'm uncertain. I can't tell from the writing.
Anasema kwamba ni Judge Luka kwamba mwezi wa 3 yani 22 mwaka ule ulipita kwamba ulishindwa kufika kwa mahakamani.
I then have a request for hearing with the judge for the judge to hear my case and for me to explain my case.
Sema kwamba alafu tukaambiwa kwamba tunataka maneno yangu nikuja nimweleze judge mwenyewe kwamba ni asikie.
So is that your understanding, Mr. Makata?
Meelewa? Yes, I understand.
All right. Ms. Winters, is that your understanding?
No, Your Honor, that's not, there was a hearing last year, and that was denied. And then in December, there was a petition for partial payments that was filed by the defendant to allow payments of $25 per month. The court entered an order for the partial payments of $25 a month. The first payment was to be made on January 30th.
Ms. Winters?
Yes.
There's no way we can interpret that if you're just, I need for you to slow down so we get some interpretation to the defendant who does not speak English. So you may proceed, just understand you got to pause so we can interpret some of that.
All right. Go ahead.
Go ahead.
So you can proceed. I just need for you to slow down a little bit and pause so we can have some interpretation.
All right. I just trying to point out for the court and to the defendant that there was something in the in-between between March of last year and today's hearing.
Maelewano kuhusiana mwenye kuumizwa na mwenye kuumiza mwaka ule ulipita mwezi wa 3.
All right, and is that the motion? Is that the installment payments that was set up?
Yes.
Nauliza zile pesa kwamba ni mulipanga kwamba ni utalipa hizo kidogo.
All right.
Na sharia nasema ndio.
And now we have the motion to set aside the installment payments. Is that my understanding, Ms. Winters?
Kwamba hapa saa hii
kuna
tumesimamia kwamba yani tuongee yani hizo pesa ziko namna gani? Anasema ndio.
All right. So I guess my question, go ahead.
No payments have been made.
Hakuna pesa zililipwa tangu tumeadiana.
All right. And if just so I make sure we're working from the same document, there was to be $25 every month starting January 30th. Is that correct?
That's correct.
Anasema kwamba ni kuna faranga pale imeandikwa 25 kuanza mwezi wa kwanza tarehe 30. Hiyo ni ukweli? Anasema ndio.
All right. So I'll have you interpret it. So the order indicates that Mr. Makata is to pay $25 every month from starting January 30th, 2023.
Anasema kwamba ni jaji anasema kwamba nataka nikueleze kwamba ni muliandikishana kwamba ulipe 25 kutoka mwezi wa kwanza January kwamba 30 kwamba ni kila mwezi ulipe shilingi 25.
Is that correct, sir?
Hayo ni maneno ya kweli.
Hayo niliandikisha lakini sikujua kama ni namna hiyo kwa sababu hawakuwa wananitranslate.
Yes, that's correct. I put down the $25, but it's not true because he didn't know that the money is gonna go to them, and also he didn't have a translator on that day.
Mimi niliweka hiyo nikijua kwamba ninaweka ili kuonyesha kwamba niko tayari kusikilizwa hii kesi ili nijue nini kitaendelea baadaye.
I put the $25 in order the judge should do a hearing to this case.
Na leo nimekuja ili nisikilizwe kwa sababu sijawahi kusikilizwa na sikupata nafasi ya kusikilizwa kwa sababu sikujua nini cha kufanya.
Today I came to this hearing so judge will hear what happened and what was going on.
Kwa sababu yote yaliyotokea ni uongo.
So whatever they say, it's not true.
Sasa kwa sababu sikujua lugha na nini cha kufanya na nilikuwa mgeni katika hii nchi, niliingia kwenye matatizo bila kujua.
And I am new to this country. When I was signing those papers, I didn't know what I'm signing to.
Hata kile kilichotokea hiyo siku wanasema gari iliharibika ni uongo, sio kweli.
Even the day that they're saying the car was damaged, it's not true.
Ninasema mbele ya koti ni uongo.
And it's true. I'm saying this true in front of judge, and it's not true.
Watu tunaongelea habari za kulipa pesa, lakini kiukweli hakuna kilichoharibika, na ndio maana nilikuja ili wanisikilize niseme kile kilichotokea.
I am here to talk about the payment, but the payment that I arranged that day, it wasn't the payment that I'm going to pay. I wanted the judge to hear my case.
Nilijaribu kufanya mpango wowote ule wa kuweza kuingia kwa koti kwa njia ya Zoom, lakini judge alikuwa anisikilize kwa sababu ya lugha, hatukuelewana.
On that day I was on Zoom and I tried to speak with the judge. The judge couldn't hear me because I couldn't speak English.
Sasa sijui kama judge ananiruhusu niseme kilichotokea.
So I don't know if judge will allow me to speak what happened.
All right. So Ms. Winters, you understand the nature of the argument is that at the time of the hearing, I have defendant failed to appear for the hearing. That's what it says.
Anasema kwamba pale inaonyesha kwamba ni wewe hujaingia hiyo siku.
Niliingia kwa Zoom lakini hatukuelewana lugha na judge akanifungia.
I was on Zoom, but I was not able to speak with the judge, and right away judge kicked me
out. Na mara ya pili niliingia tena kwa Zoom nikiwa na mtu pembeni, judge akasema sitakiwi kuwa na mtu pembeni.
And the second time also I went into Zoom and I had someone beside me to speak on behalf of me. The judge said, no, I want you to come.
Sijawahi kusikilizwa tangu mwanzo mpaka leo.
So since the incident happened, I didn't give up my hearing.
All right. So Ms. Winters, you understand you understand the nature of the indication for the request to set aside the defendants indicating that there was. Go ahead.
Anasema kwamba umeelewa sasa kwamba vile alisema mwenye kuumiza kwamba habari zile alisema sahihi.
And so there's an indication that he did not have a chance to tell his side because of the lack of interpreter.
Anasema kwamba hakukuwa na muda wa kuongea matatizo yake kwa sababu hakukuwa na mtafsirishi.
Do you understand the nature of the objection, Ms. Winter?
Umeelewa sasa haya makatalio mwenye kuumiza mtu anakataa?
I'm uncertain, Your Honor, because the record, my office appeared at the motion to set aside the default judgment, and there wasn't anybody there in Zoom, and that was over a year ago. You know, and since then, the defendant petitioned the court for a partial payment order, which was entered. So I'm unsure as to when these other attempts at appearances happened, and the only reason why we're here today is because of my petition to set aside the partial payment order.
All right, thank you.
Anasema kwamba ni haya mimi sijakubali kwa sababu ya nini? Ulipita mwaka kutoka mwezi wa 3 mwaka ule ulipita na mwezi huu wa 3 ni mwaka katikati hii. Leo nimekujia kwamba ni mwenye kuumiza mtu atueleze kwamba ni vile ataanza kulipa pesa kwa sababu hakuwa analipa pesa zile alikubali yeye mwenyewe.
All right, so it's the court's decision today. I'm going to take the motion under the objection under advisement. I'm going to set it for full hearing.
Anasema kwamba ni sahihi haya yote anataka yakataa ya kwako na kwako. Kila mtu atakuja hapa hayaseme ya kwake.
Right, and then we're going to put it on a date to set aside some time to take testimony. I want everybody here live.
Anasema kwamba ni hiyo siku nataka kila mtu afike hapa. Wewe na mwenye kuumizwa wakuja watuambie yale yalitokea.
And we'll make sure we have the same interpreter to come in and make sure that there's no misunderstandings.
Anataka kwamba mimi nikuje hapa hakuna kusema kwamba nisijaelewa hivi sijaelewa. Nyinyi wote kuja hapa.
I would tell both parties to bring any evidence they want the court to consider in relation to this matter.
Anasema kwamba nitamwambia yule aliumizwa na wewe huko mulete ushahidi wowote mko nao.
And such evidence should be tangible, which means I must be able to mark it.
Anasema kwamba nikue karatasi kama ile kwamba nimuonyeshe kwamba ushahidi wangu ni huu.
Right.
With regard to, I don't understand, Your Honor. We have a
There's-
petition to set aside a partial payment order.
Correct.
And the defendant filed a response to the petition to set aside a partial payment order. And now what are you setting?
I'm setting it a hearing on the motion to set aside to make sure everybody understands what's
Set
going
aside the
on.
default judgment or the petition for partial payments?
Set aside the petition for partial payments at this time. That's what the objection was. The objection, which is hard to read, it says, I'm requesting a hearing with the judge for the judge to hear my case and for me to explain my case. I want to know why the defendant who has signed $25 a month.
Ndio kwamba ni pale kwa karatasi kumeandikwa kwamba ni mwenye kuumiza amesema kwamba nataka kujua sababu gani kwamba ni mimi nalipa hizi faranga na pia umesaini hizo faranga.
Is unable to make those payments or refuses to make those payments.
Kwamba ni hiyo siku nataka kujua kwamba ni sababu gani anakataa kulipa hizo pesa au hana hizo pesa za kulipa.
But I'm just assuming that we're going to take some testimony, and today's not the day for doing that since I have a morning docket.
Anasema kwamba ni hiyo siku sasa ndio siku nataka niojie huku na huku, na leo asubuhi sina hiyo muda kwamba ni kusikia kila mtu habari zake.
So do you understand the nature of the court requesting a formal hearing?
Kwamba unaelewa sasa, yani mahakamani mwenyewe yani wanauliza.
I mean, we were fine with the $25 a month payments. I mean, if he wants to start making those payments, you know, the case, I'm uncertain where we're going with
it. He doesn't want to make those payments, Ms. Winters, but I'll let the interpreter interpret that.
Mwanasheria anasema kwamba sisi tuko sawa kama anaweza lipa hiyo 25 kila mwezi. Unataka kulipa hizo pesa bila kujua, kwa sababu jaji anasema kwamba yeye hataki kulipa hizo pesa.
Mimi siwezi nikalipa pesa ambayo sikuharibu gari ya mtu.
Yeah, I do not want to make that payment.
Like he does not want to make those payments
because I didn't do any accident.
So, but there's an order out there requesting that he make the payments. We're going to take some testimony on that order, and there's an indication. If he's just saying, and I'm going to pull the previous hearing to see if he showed and if he didn't show.
Anasema kwamba mimi hapo naona kuna 25 kwamba umesign wewe mwenyewe, na pia nitatoa kwamba yale siku mbili umeambiwa kuja hapa kwa mahakamani au ingia kwa Zoom, nikikosa kwamba anakuja ingia kwamba hiyo itakufuatilia.
But I have to set this so that we have a little bit of time to put aside for this.
Anasema ni lazima nipeleke mbele tukue na muda kila mtu akuja anifafanulie yale yalitokea.
So I'm going to indicate we're going to review the past hearings.
Kwamba tutaangalia yale kwamba siku ulikuwa umepangiwa.
And I'm going to set it for a formal hearing, which is live.
Kwamba nitafanya kwamba sisi
So
wote tukuje
we can't appear by Zoom, Your Honor?
You can appear any way you want, Ms. Winters. I need the interpreter here and Mr. McCarty here so that we have no misunderstandings as to a language barrier. Do you understand that?
Ni wewe unaweza kaa kwa Zoom, lakini namtaka mstamukata hapa na interpret kwamba ukue hapa, yani hakuna kukusema nimekosea tena.
Do you understand that, Ms. Winters?
Umesikia hiyo, Ms. Winters?
We can appear by Zoom.
Yeah, you can appear by Zoom, but if you want to put on evidence and you don't have a witness here, we're going to have a problem.
Nasema kwamba kama unataka kuleta ushahidi na hakuna mashahidi hapo yaliingia hapa, itakuwa ni shida.
I don't know your case. There's an order out there and he's refusing to adhere to the order. So if he wants to testify, I'm going to allow him to. You get to cross-examine him. You're going to do so by Zoom.
Anasema kwamba kama yeye anakataa, hata kama amesema kwamba nimekubali hiyo 25, leo amenikatalia, na mimi siwezi mlazimisha kwamba alipe hiyo 25. Natakikana wewe kuja na habari, alafu kila mtu unauliza swali unajibiwa.
If you're good with cross-examining by Zoom, that's fine.
Kama uko na haki kwamba useme kwamba haya hayapo, yani kwa Zoom pia hamna shida.
Okay.
All right. So I'd like the interpreter and Mr. Mukata here live.
Anasema nataka interpreter na mstamkara pia wa kwamba ni uso kwa uso.
All right, Ms. Winters can come by Zoom if she chooses.
Kama yeye anataka anaweza kuwa kwa Zoom, hakuna shida.
We'll set it for formal hearing. I'm going to give about an hour for this.
Kwamba nitawapa ili kila mtu dakika 30 aongee kwake.
Yeah.
April 13th at 1:30.
So it'll be April 13th
Mwezi wa 4 tarehe 13
at 1:30.
saa 7:30.
I'm still, Your Honor, I appreciate everything that the court and the defendant are saying. However, is it the defendant's contention that he did not file a motion for partial payments?
He's saying that he objects and will not pay that, because he had no understanding of what was going on during the proceeding because he did not have an interpreter.
Anasema kwamba aliuliza kwamba yeye alikuja kuandika makaratasi ya kusaini kwamba nitalipa 25. Ndio jaji anamwambia ndio kwamba nilikuja kuandika lakini sikuwa na mtu wa kunitafsirisha. Siaelewi hayo.
So it is this court's intent to clear up any ambiguities concerning the language barrier and the order, and I'm going to do so live. We need some time to do that.
Sema hii mahakamani yangu hapa jaji anataka ahakikishe kwamba ni yeye kwa kusema sina mtafsirishi, sikuelewa yale yalitokea, hayo ndio nataka niwaweke sawa.
Your Honor, can I ask, did the defendant file the motion for partial payments?
He may have, but I have no idea who helped him or where he received the information concerning that.
Anasema kwamba kama nikiuliza nani aliandikisha hizo, jaji anasema mimi sina habari na sijui kwamba mwenye aliandika kwa kusema kwamba nitalipa hizo 25.
So in the formal hearing, we have an interpreter here and we can clear up any ambiguities. That's set April 13th at 1:30.
Anasema kwamba tutakuja hapa mwezi wa 4 tarehe 13 saa 7:30 tukuje tuongee kuhusiana kwamba yeye hajasikia kitu chochote kuhusiana leo.
Okay, anything else for the record? Docket 2102-605, Mr. Mukada.
Mtamgaa, kuna kitu chochote unataka kuongeza kwa hii habari mwenye na sheria alikata? Hapana.
Hapana.
No.
Okay, you received notice. Ms. Winters, you have that date, April 13th at 1:30, and you'll get sent a notice. We just provided a notice to Mr. Mukada.
Yes, Your Honor, I have that.
Ninataka utatumia hiyo karatasi kama hii mtu alipewa hapa Mr. Mukada. All
right. Thank you, everybody, for your appearance today. We'll see everybody here on April 13th.
Thank you. Bye-bye.
Thank you, Ms. Winters.
Thank you, Your Honor. Bye-bye.
All right. Thank you for your assistance today. All right. I'll see you here on the 13th.
Yeah, all right. Thank you.
Oh, Manny. Abdallah. Yes.
All right. And so we're on the record in docket 22-02536. That is Nina Shambumba versus Maya Musakaluma. This is the time set for a pre-trial in this matter. Today's April 3rd, right? Is there a Nima Shamumba in the courtroom?
Yeah.
That's you?
It's me.
Oh, he's the defendant? Okay. Is there a Nima Shamumba in the courtroom? All right. And I don't see a Nima Shamumba I don't see the plaintiff in the physical courtroom. Sir, you are Mia. Please pronounce your last name, sir. Okay, please come on forward. All right. And so for the record, this was scheduled for 8:30. It is now 9:12. It would appear the plaintiff has failed to appear. I'm going to indicate for the record that the plaintiffs served the defendant, and you were served. That's why you know to be here, sir.
I'm not defendant.
You're not the defendant.
Yeah, I'm the husband for Nema. Shamam.
I have you. You are Mia, Musobokelwa.
Yes, sir.
I have you as the defendant, sir. I don't have you as the moving party here. Okay. But I do have that you were served and that's why you're here. I do not have at this pretrial conference the moving party who's the one who's suing you of NEMA SHMAMOUMBA at this pretrial.
She's my wife.
She's your wife.
Yes, sir.
Okay. And she's not here. Is she your current wife?
We live together, same house in my house.
All right. Well, let's adjourn this. Let's adjourn this for pretrial so both parties can be here, okay? So we're gonna adjourn this to another date so that both parties can be here on another date, all right? All right. Because her being your wife changes whether I'd like to see everybody here first before I indicate what's gonna happen in the case, all right? All right, so we'll adjourn. Plaintiff is T's wife. We'll adjourn the pretrial to have all parties here, all right? And new pretrial date.
Wednesday.
Might as well put it with the Thursday one. Might as well, all right?
Sure. How about 2:30 on April 13th?
Okay. So we'll set it for 2:30 on April 13th. Do you need an interpreter, sir?
Yes, sir.
All right. So, and did you understand the last language that was spoken? What language is that?
Swahili.
Swahili?
Yes.
Okay. So we will have an interpreter here on that date for the other hearing, and we'll just make it apart for this hearing, okay?
Yes, sir.
Okay. Swahili interpreter needed. And I have the plaintiff's address at that 1131 Foreign Street.
That's my house.
That's also your house.
Yes, sir.
I need you both here, okay? I need your wife here and I need you here. Go ahead.
Yes, sir. But you need to inform her because
She'll get a notice to that address.
we live same house, but we are separate.
Okay. She will get a notice, but somehow get it to her. I mean, that she needs to be here, but she will get a notice to that house. You both will get a notice, okay? And then we'll decide what we're doing when we get you both here, okay? All right. Needed. So that date is April 13th at 2:30, okay, sir? All right. Anything else for the record? Docket 2202-536, or you're all set, sir? We'll have an interpreter on that day.
Yes, sir.
All right. You'll get a notice from my court clerk. She will get a letter sent to her. All right. And then show up live on that day and we'll have the pretrial on that. All right. All right. You're all set. We'll also have an interpreter here on that day. Okay. You're all set. Ms. Sutter, you're here for our 9 o'clock, correct?
Yes, I am, Your Honor. I apologize for my
And
tardiness.
Ms. Robinson's here.
Yes.
Joining us. She had to sit through all that lovely civil stuff. And so, but we are waiting for a city attorney, is that correct?
She and I were just in Judge Murphy's Zoom, so we're both heading
Yeah,
to
that's
Livingston Court.
right. My understanding she's gonna zoom in just a second.
Your Honor, if we have a moment, may I have a breakout room with Ms. Weigel, please?
Absolutely. So I'm gonna have Ms. Sutter and Ms. Weigel placed in a breakout room.
You getting up in here, huh? Oh, no. That's what I'm saying, I know.
Would the person on Shanique's iPhone please identify yourself?
Good morning. I'm here on behalf of Monopoly Apartments. I'm the property manager.
All right, property manager for, what's the number of your case, ma'am? Oh, I see it, 22. It's 22. So Monopoly Apartments versus Donovan Garza?
Correct, yes.
All right. All right, stand by, ma'am. That's set for 9:30, and we've got some other hearings that are in front of, but you're in the right place. All right, ma'am?
Thank you.
All right, so this 22-01-655 was originally set for 8:30. It is now, I'm sorry, it was set for 9 o'clock. It is now 9:23. I do not see Mr. Williams in the present courtroom. I just checked the person who came in. I do not believe Mr. Charles Williams is in the physical courtroom. Council did go outside to see if there was some Mr. Williams in the hallway. Miss Williams, it appears that the defendants failed to appear. How are we proceeding?
Your Honor, I'd like to request a bench warrant bond forfeiture with a 48-hour hold.
Any objection to a bench warrant bond forfeiture with a 48-hour hold, or any comment, Ms. Roberts?
No objection to the 48-hour hold.
All right, so the court will issue a bench warrant and bond forfeiture for failure to appearance with a 48-hour hold. Anything else on the record, docket 22-01-655, Ms. Williams?
No, Your Honor, thank you.
Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. You're all set. Then Mr. Milks, you're here on Mr. Reedy?
Yes, sir.
All right.
Yes. We do have LT hearings.
And Ms. Sutter is meeting with Mr. Weigel, or Miss Weigel, right now.
I also believe she has.
That's why I don't try to sworn into.
Yeah, I don't see Mr. George
He's
right
on
now.
Zoom.
He's on Zoom? All right.
I think she's talking to him.
All right, so you're David George?
Yes, sir.
All right, your public defender is in a breakout room with another person. And then once we get her back in the courtroom, we'll put your case on the record. All right, sir?
Okay.
feel so bad. There's no reason why I should. No, I got it.
All right, Ms. Sutter, you had the opportunity to speak with Ms. Weigel.
Yes, I have, Your Honor. Thank you.
All right, and Ms. Williams is here in the court. I also have Mr. George here. Did you want to speak with him after we called Ms. Weigel's case? Or have you already spoken with him?
I did speak with him. I think I have a little extra information to give him, so just very brief breakout room with him.
All right, so let's call Ms. Weigel first. So we're on the record in docket 23-0020. And then we have accompanying tickets 22L2769362 and 22L2769336 or 361. Well, there's 3 extra tickets. Okay. All right. All right, appearances for the record.
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. Weigel, who joins us via Zoom.
And ma'am, you are Rita Weigel?
Yes, Your Honor.
All right, you can hear me all right, Ms. Weigel?
Yes, sir.
All right, Ms. Williams, this is the time set for a City of Lansing pretrial. How would you like to proceed?
Your Honor, I would like to request an adjournment for 3 to 4 weeks for compliance purposes.
That's correct, Your Honor.
All right, so I can grant an adjournment for that time period, but it'll be the last one because that'll put us right at 90 days almost.
Understood, Your Honor.
I understand.
All right, so we're gonna request an adjournment for compliance purposes on all the files. Compliance and request adjournment. And we'll get a new date. You said about 4 weeks out?
3 to 4 weeks.
3 to
yes.
4 weeks out.
Let's do April 20th.
So we'll do April 24th
Okay.
at 9 o'clock. April 24th at 9 o'clock. Writing as I'm saying that in all these files. All right, so Ms. Weigel, April 24th at 9 o'clock is the date for your next pretrial. So do anything in regard to your that you need done in regards to your license and what you and Ms. Sutter talked about, okay, ma'am?
Yes, sir. Thank you so very much.
All right, anything else for the record in docket 230020 and the accompanying tickets, Ms.
Your
Williams?
Honor, thank you.
Ms. Sutter, anything else?
Nothing further. Thank you.
All right, thank you. You should be all set. We'll see you on the 24th, Ms. Weigel.
Okay, thank you so much, Your Honor. Have a great rest of your day.
You too.
Thank you.
And then I'm gonna have Ms. Sutter placed in a breakout room with Mr. George so that she can give him some updates. And then we'll go ahead and we'll call that case.
Thank you.
And Mr. Dua, you're here on your cases?
Yes, Your Honor, and 2 of those are dismissals.
All right. So we can probably put those, which 2 are those, Mr. Dua?
0913 and 4397.
Yeah, I have 4397.
Oh, and then must be 4396. Sorry about that.
And 4396. All right. All right. So we're on the record in docket 2204396. And that is Indus Realty LLC versus Kevin Devenbaugh. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning. Sam Dua here on behalf of plaintiff.
And Mr. Devenbaugh is not present, but my understanding is there's going to be a motion from yourself on behalf of Indus Realty, Mr. Dua.
Correct, Your Honor. The defendant has relinquished possession. Plaintiffs would move to dismiss this matter as it is possessory only. And I have a dismissal in front of me that I'll be submitting to the court shortly for the file.
All right, perfect. Plaintiff moves to dismiss. We'll submit dismissal. And the defendant has vacated the property.
Thank you.
Anything else on the record in docket 22-04396, Mr. Dua?
Nothing further, Your Honor. Thank you.
Thank you. You're all set on that one. And then we have docket 22-04397. That's Rhonda Wade versus Anthony Geiger McClitchy. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
And it appears that Anthony Geiger McCleachy is not in presence today, although it's my understanding after speaking with you, Mr. Dua, that you do have a motion for the court.
Yes, Your Honor. The defendant stopped by my office as soon as we opened this morning and turned in keys. Therefore, this possessory action is no longer needed and plaintiffs would move to dismiss. Just like the other one, I have a dismissal in front of me that I will be following up with the court to get it into the file.
All right. All right. So with that understanding, the defendant's vacated the property. Plaintiff moves to dismiss and will follow up with an order. Anything else for the record? Docket 22-04397, Mr. Dua.
Nothing further, Your Honor. Thank you.
Thank you. And then we've got your last case, and we'll wait 15 minutes on that one. That one we'll wait. That's set for 9:30, and we've got about 5 minutes on that. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Dua. All right, Ms. Sutter, you're all set on Mr. George?
Yes.
All right. So we're on the record in docket 22-01206, 22-01207, and an accompanying ticket of 22L271071. Excuse me, that's City of Lansing versus David Anthony George. Would the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. George, who joins us via Zoom.
And sir, you are David Anthony George?
Yes, sir.
All right, and you can hear me all right, Mr. George?
Yes, sir.
All right. This is the time set for City of Lansing pretrial. Ms. Williams, how are we proceeding today?
Your Honor, I would like to request an adjournment for 3 to 4 weeks for compliance purposes.
So similar. All right, Ms. Sutter, is that your understanding?
It is, Your Honor.
Okay, this is the second request for an adjournment, and it is granted, but as the last file, that date puts us right at about 90 days, which is the extent of the adjournment. Second request for adjournment. Can we put it on that same date? Okay. Adjournment. So it is adjourned, and this will be the last adjournment for April until April 24th. At April 24th at 9 a.m. April 24th at 9 a.m. April 24th at 9 a.m. So, Mr. George, your case is set for April 24th at 9 a.m. Anything discussed with Ms. Sutter in regards to compliance purposes, please make sure you have done by April 24th at 9 a.m. Okay, sir?
Yes, sir.
All right. And is that all for the record in the two dockets, 2201-206 and 2201-207, and the accompanying ticket, Ms. Williams?
Yes, Your Honor, thank you.
Anything else, Ms. Sutter?
Nothing further. Thank you.
All right. We'll see you on April 24th, Mr. George. You're all set.
Thank you. So I can leave the courtroom now?
Yes, you can.
Yeah, you're free to leave the Zoom courtroom. Thank you for your appearance today, sir.
Okay, thank you.
Are you all set, Amani?
Yes, I'll see you in the afternoon.
All right, take care.
Thank you. Sorry I was late this morning.
No, you're fine. We knew where you were.
That's good.
All right, Mr. Dua, we can call the other Monopoly Apartments case. So we're on the record in docket 22-04400. That's Monopoly Apartments versus Donovan Garza. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Sam Dua here on behalf of plaintiff.
All right, and Mr. Garza is not in attendance. He is not in the Zoom courtroom. I don't see him in the physical courtroom. This was set for 9:30. It is now 9:45. I will indicate for the record that Mr. Garza was previously failed to appear for pretrial on March 22nd, and there was subservice attached. That's why we adjourned it to this date. It would appear that the defendants failed to appear for the second pretrial. Mr. Dua, how did you want to proceed today?
Thank you, Your Honor. Plaintiffs would move for a default possessory judgment to enter based on the defendant's twice non-appearance before the court. The rent to retain possession amount is $3,450. There were $163.86 in costs in the matter, totaling $3,613.86 to be paid on or before April 13th, 2023 to prevent order of eviction from issuing.
All right. And it's my understanding that this was a non-payment case, and that partial payment would not be accepted for the April 13th date. Is that correct, Mr. Dua?
That is correct, Your Honor. Thank you.
All right. And you'll follow it up with an order to that effect?
I will do so.
All right, so the default is granted. I'll sign an order to catch up with the file. The numbers have been placed on the record. Anything else for the record, docket 22-04400, Mr. Dua?
Nothing further this morning. Thank you, Your Honor.
All right, thank you. You're all set, Mr. Dua.
Have a good day.
You too.
Yeah, he has two.
The same one?
This one is the same one. It's just next one.
It's Monday.
I could have said 95 like I normally do.
I'm gonna take a break and allow everybody to
All rise.
work themselves out here.
Nope, that's yours.
I'll start stickering.
Well, if you just want to write them, I'll stick them.
That's what I was gonna do. Do you have online
Yeah.
your book? I didn't want to mess up your career. Let's hope I can count to 20 and go back. Last week.
Answer your questions. Answer your questions. Two aliens and whole day. Two things. They have to wait. Yes.
Any exhibits?
No, ma'am.
Thank you.
You're welcome.
Mr. Hess?
No exhibits.
Thank you.
I don't know what it is, but I do watch everything that I've seen with the male defendant. It's just constant. Yeah. And in various states. Yes. Circumstances are irrelevant. Yeah. 100%. Was a month somewhere. No. Just I just would rather not see. You can thrust yourself in that situation. No wait, that's true. So it was humbling to see that the office did not collapse during my vacation. Yeah, close though. Yeah, it did. I heard that HR messed up with you. Apparently, I didn't realize we were doing it until some sort of email or something like that. So this was like, justification or HR just they just posted the stamp it with an official seal. It's a policy. Let's wait until something. And then it's false. So you can't imagine. As I told you, keep it in time. Well-oiled machine, pension machine. Those are not mistakes. People get very yeah. Take a little bit longer than it should. Absolutely. Might be some committee meetings, some adjournments. That's refreshing. Oh yeah, that's really one of the items I talked about. As per my previous meeting. Yeah. As I explained. I see one gentle reminder.
No. Sometimes I don't know if this is a trick question. It's not. Yeah. Promise. No, I don't think anything. That's very comforting. Yeah. Yes, that was correct. I think she's got not good. She should try. She seems to have good form with good success. I can see that. I can definitely see that. Because sometimes I think she's still together. And that's also fair. She somehow makes it work for her. Yeah. That's very yes. Some of these fights are absurd. Fights with the city township. Seriously. Or yeah. Who's the Colin Harkness, yeah. Represent from the township. And then state board represents Delhi township. And he's a kind of a hard ass, is he? Yeah. It's amazing how least important criminal cases are. Seriously. Yes. Oh, I don't know, 50s or 60s. Retired cop. He does a lot of municipal law. They do like property tax appeals. He just always is. Just major. I forget the lady who represents the city of Mason. They file a case once a week. And you get some random little places that happen to have city. But still, yeah. So oh, it's until the judge comes back in. But you're right. I bet you the prosecutor's calling it. Okay. Yeah. No, I'm not hoping something. So you go to the new courthouse? Yeah. No, never been to jail these ones. They put the millage back, but I didn't realize they were including the courthouse. Not just for the sheriff's office, but apparently the courthouse is kind of a tag along. Add on. Yeah, I guess I didn't realize that either until it seemed like they're both rooms like I don't know the whole official process. Right. Pretty good luck with these concepts. Remember there didn't used to be concepts. Oh yeah, that was and this stairwell here is popular. Yep. Absolutely. I don't know, expect used to be. No. We're good. How are you?
Was one here
Yes, she left maybe 20 minutes ago.
Amanda Boyle?
No, not Amanda O'Boyle. If you go to their lobby and refuse to leave, they will come out eventually.
I'll do it.
Yep. Just on the invoice. I was an extern with the city attorney, but the city was so poor that they didn't have reception. As an extern. When I was in school. Yeah. What was it, where they had attorneys rotating, so they get. Yep. Right. And I realized, hey, we just do it through a phone. I remember that. That was. Okay. Very. Yeah. That's because they're wet banana ears. That's good. Scrapping with each other. You know? I give them be a fight. Thank you. It's a good emotion. I get so
Are we
mad.
writing them off?
At least two.
Okay.
Well, hold on.
Running Mr. Hess's time?
Yes, and then at least one other one.
Okay.
Point is, I get so
How's that?
upset with all the parties.
Take your time. I was just curious before I start to do something else if I should stay closer.
I'm ready. I'm ready for both. Yeah.
It's gonna be really impressive with the time. It's 8 a.m. Like, oh,
Well, thank you for that.
Yes.
I
mean, I know I can be a bit of a control freak, but
No, I
intent
appreciate that.
to that one.
I appreciate it. So I'll leave it to.
Yeah. Something here.
All rise.
Steven? Which case are we doing first?
Strunk.
Strunk?
Whichever you prefer.
So we're on the record in docket 23-00363, people of the state of Michigan versus Emily Strunk. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
Thank you and good morning, Your Honor. Edward Hess on behalf of Ms. Strunk. Ms. Strunk is to my right at the council table.
And ma'am, you are Emily Strunk? Okay. This is the time set for preliminary examination today. Mr. Stevens, how are we proceeding?
It's my understanding the parties will be running an examination this morning.
All right. Are there any preliminary matters to come to the court's attention before we start the preliminary examination from the people?
Nothing other than sequestration of witnesses, nothing on behalf of the people.
All right. Mr. Hess?
Yes, Your Honors. As far as sequestration goes, Ms. Strunk's husband is here. I think he's a potential witness, so he probably would have to excuse himself.
That's true. And I'll leave it to counsel. Any potential witnesses other than the investigating officer is excused from the hearing today. So if you are a potential witness, you have to leave. You should leave the courtroom just by sequestration order, which is both sides, which is pretty perfunctory. Okay, sir?
All right.
All right. You should be all set. Anybody else who comes in during the hearing, if either side sees a potential witness, let the court know and we'll exercise the sequestration order.
Besides that, Your Honor, I would just like Ms. Strunk to confirm on the record that she is rejecting the offer that the people extended for her to plead guilty to improper transport of a firearm, which is a 2-year high court misdemeanor, and she's pleading not guilty and she's asking to proceed with this hearing. Is that correct?
All right, Ms. Strunk, you're proceeding with the hearing. You've rejected the offer that has been made in this case. Mr. Stevens, you may call your first witness in regards to this prelim.
Thank you, Honor. People call Officer Rachel Logsdon.
Okay, Officer Logstrom, I'm going to have you come up here. I'm going to have you state and spell your last name for the record.
Rachel, R-A-C-H-E-L, last name's Logsdon, L-O-G-S-D-O-N.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, please have a seat here and project for recording purposes. Mr. Stevens, you may proceed.
Okay. Ma'am, are you employed?
Yes.
How are you employed?
A police officer for Lansing,
And how long have you been employed as a police officer for Lansing?
20 years.
What is your current assignment?
Patrol officer,
Okay. And how long have you been in that assignment?
20 years.
I'm going to draw your attention, officer, to the date of December 14th, 2022. Were you working on that day?
Yes.
And on that day, around 11:35, did you have the occasion to respond to a complaint involving a gun?
Yes.
Okay. Were you alone or were you joined by any other officers?
I was joined by other officers.
Where specifically did you respond in relation to this call?
I responded to 120 West Barnes.
Okay. And why did you respond to that specific location?
A female had called in saying that she was being chased by a man with a gun.
Okay. And did you ultimately arrive at 120 West Barnes?
Yes.
Okay. And were you joined by, I think you said a moment ago, you were joined by another officer or officers?
Yes.
What other officers were you joined by in this call?
Officer Rendon.
Is that Brian?
Yes.
And the last name is R-E-N-D-O-N?
Correct.
Did there come a point where in connection with this call, you had to travel to a different address or location?
At the end of the call I did, but during the call I remained at 120 West Barnes.
Okay. End of the call, where did you ended up traveling to?
1601 Barnes. I'm sorry, Coleman. 1601 Coleman.
Okay. 1601 Coleman, is that within the city of Lansing?
Yes.
Ingham County, state of Michigan?
Yes.
Did you have contact with anybody at that specific address on December 14th, 2022?
I believe I just spoke with the other officers that were at scene on that call.
On that date, did you ever have contact with an individual name identified as Emily Strunk?
Yes,
Would you recognize Miss Strunk if you saw her again?
yes,
You see her in the courtroom today.
I do.
Can you please point her out and describe an article of clothing, please?
She's seated there. And she has a purple hoodie on.
I want to let the record reflect that Officer Logston has identified the defendant in this matter.
Any objection from the defense as to the witness identifying the objection?
No objection for this hearing. Thank you.
Okay. For purposes of preliminary examination, the witness has identified the defendant.
Thank you. Where did you have contact with Miss Strunk on December 14, 2022?
Outside of 120 West Barnes.
And was she with anybody?
Yes, she was.
Who was she with?
I believe his name was Tyrone Davis.
Okay. And you said outside. Was she just standing outside or something else?
They were both outside.
Did there come a point where you were investigating or asked Ms. Strunk about this call that you responded to?
Yes.
Okay. And in doing so, did you recover an item relevant to an item of evidence relevant to this investigation?
Yes.
What did you ultimately recover?
Firearm.
Okay. Where was this firearm?
It was located in a vehicle that was parked in the street.
How was it that you ended up locating and recovering a firearm inside of a vehicle?
During the conversation with Tyrone Davis, we had asked permission to search the vehicle because we had received information that he had also had a gun at the scene of the crime. Mr. Davis did give us verbal permission to search his vehicle. And when asked if there were any firearms in the vehicle, Ms. Strunk advised that she did have her gun inside of the vehicle.
Okay. And did there come, and as a result, there came a point where you ultimately seized that item?
Yes.
Familiar with firearms?
Yes.
The item that you seized, was it a real firearm?
Yes.
Is it loaded?
Yes.
Would you end up, the phrase I'll use is running the firearm in lean?
I did.
Okay. What was the point of running the firearm in lean?
To find out who the gun was registered to.
And did that search result anything relevant to this call that you responded to on that day?
It did come back registered to Ms. Strunk.
You recall anything regarding the vehicle itself, make, model?
I believe it was a blue Toyota.
Okay. And did you end up running that vehicle in lean?
I did.
Or SOS?
Yes.
And did that come back registered to anybody in particular relevant to this this call or investigation?
I believe it came back registered to Mr. Davis.
That be Tyrone Davis you referred to a moment ago?
Yes.
And I think you, if I recall correctly, you characterized him as either husband or boyfriend of Ms. Strunk.
I'm not sure what the relationship is.
But you're some relationship between the two.
Yes.
Mr. Davis and Ms. Strunk. Correct. Now, the firearm was inside of that Toyota.
Yes.
Was it open and obvious within inside the Toyota, or was it concealed in anything else within that vehicle?
I found it inside of a bag on the front passenger floorboard,
Okay, when you say bag, how would you describe the bag?
just like a woman's cloth bag.
Okay, like a purse, a backpack, something else?
I don't remember exactly what type of bag it was.
Okay. All right, and did you ultimately speak with Ms. Strunk about this weapon that you ultimately recovered?
I did.
Okay, did you, in speaking with her, did you ask as to how the weapon ended up inside of the vehicle?
I did.
What, if anything, did she tell you regarding sort of that line of questioning?
Ms. Strunk advised that when she had left her house that morning, she had grabbed the bag. She stated that they were in a hurry. Normally she puts the bag in the trunk of the vehicle, but this morning she just placed it on the floorboard and kind of forgot that it had been in there.
So is it fair to say, in speaking with Ms. Strunk, you learned that the gun that was registered to her was placed in the bag in the car by herself, Ms. Strunk?
Correct.
Thank you. No further questions.
Cross-examination.
Thank you. Officer, is it part of your practice as a police officer to write down your recollection of what happened at an incident in a police report?
Yes.
And did you type a police report after this incident?
Yes.
And do you remember how soon you did that after the incident?
It would have been right after the incident had occurred and everybody had left the scene.
And that's something you're required to do by the procedures of your department?
Correct.
And your report was your best effort to recollect what had happened in the incident?
Correct.
Okay. I have no further questions, Your Honor.
Any redirect, Mr. Stevens?
Actually, if I may, were you able to learn that 120 West Barnes address, what association Ms. Strunk had to that address?
I believe it was Tyrone Davis's mother's house.
Okay, and then as to why did Ms. Strunk indicate how she arrived at that address?
She stated they had gone there that morning to visit his mother.
When you say or use the word they, who are you referring to?
Mr. Tyrone Davis and then Miss Emily Strunk.
Thank you, Your Honor.
Anything else for this witness from the people?
Nothing from the people. Thank you.
From the defense?
No further questions.
Okay, the witness is excused. Thank you for your appearance today, ma'am.
You're welcome.
And Mr. Stevens, the people may call the next witness.
People rest.
Does the defense have any witnesses to call today?
No witnesses today. Thank you.
All right, thank you. Motion for bind over.
People move to bind over as charged with just one change. The complaint currently reads at the address of 1601 Coleman, certainly based on the testimony of Officer Ball. I'm sorry, Ball was previous name or maiden name. Officer Logsden, the location would be 120 West Barnes. But beyond that change, the people move to bind over as charged.
All right, and that 120 West Barnes is the place where the search took place of the Toyota. Is that my understanding?
Yes.
Okay. Response to motion for bind over.
Yes, Your Honor. Thank you. The key word in today's testimony from the witness, which I have written down and circled, is forgot. If we examine criminal jury instruction 11.1A, carrying a pistol in a vehicle, this informs us of the elements that the courts have found comprise the crime of carrying a concealed weapon in a vehicle. Element 2, second, that the defendant knew the pistol was there, is a very important point. You cannot be found guilty of this crime unless you know that the firearm is in the vehicle. The testimony from the officer allowed under the rules of evidence, which allow hearsay as to possession or use or entry regarding personal property, was that she was told by Ms. Strunk that indeed she had placed the bag in the vehicle, but that as far as the gun being in the vehicle goes, in the passenger compartment instead of the trunk, she forgot. Now, I don't recall her specific words, but it was something about forgetting that she had this gun in the bag between her legs. And that being said, Your Honor, I would ask the court find that, especially as to the second element, that there is not probable cause that this crime was committed, because my client did not have knowledge that she had a firearm in that bag. And I would respectfully ask that the court dismiss this complaint. Thank you.
Thank you. Any response, Mr. Stevens?
No, Your Honor, I'll let the evidence and testimony speak for itself. At a minimum, all Mr. Hess raises is a factual issue to be addressed by the jury.
Thank you. So the court has heard the testimony of the officer, and that is Officer Logsdon. I'm going to make sure. Logsdon. It appears that the location of 120 West Farms, the venue in the city of Lansing, Ingham County, state of Michigan, the date of December 14, 2022, and the identification of Ms. Strunk have all been made by probable cause evidence, which is the standard for purposes of this prelim. The elements of the crime are that first, the pistol was in a vehicle that the defendant was in. Second, the defendant knew the pistol was there. Third, the defendant took part in carrying or keeping the pistol in the vehicle. 1, 2, and 4 are obviously met by the testimony and by the search of the vehicle. We do have a factual conflict as to whether the defendant knew the pistol was there, because the defendant indicates that she did not know it was there because she forgot she put it in the bag that was in the back seat. That, as indicated by counsel, that is a question for the jury to consider. I believe at a probable cause level, the probable cause of all the elements have been met in this case, and therefore I'll bind over to circuit court, where the defendant will go in front of the jury, and the jury can decide the indication of whether she knew the pistol was there or not. I believe there's probable cause evidence to believe that she knew the pistol was there, and therefore on the elements of CCW in a weapon in a vehicle, did carry a dangerous weapon, to it a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to it that Toyota Camry that was testified. I find there's probable cause evidence to bind the case over to circuit court. So ma'am, your next date will be in circuit court. Get that date in circuit court from your public defender. All right, Mr. Hess, he will provide you with the date for the next hearing. Your time in district court is now done, and this case is bound over as charged. Anything else for the record, Mr. Stevens?
None from other people. Thank you.
Anything else, Mr. Hess?
I would ask the bond and bond petitions continue.
Any objection, Mr. Stevens?
None, thank you.
Without objection, the bond is continued.
Thank you.
That's all for the record.
Thank you.
Mr. Hess, did you want the transcript?
Yes.
Yes.
Thank you very much.
Thank you, Mr. Hess.
Thank you, sir.
Yeah.
Mr. Stevens, which file do you think you'll be going on first?
497 FY.
497. Yeah, you used to do that.
Absolutely. Nathaniel, go down there.
Yes.
R-E-E-P-Y. Yeah, I saw that. That's a name. This is a nice.
Really just emailed me and sent that home. It looks like they're gonna adjourn the trial. She just got a step. I seriously, I don't know why.
Our PVs, that 130 stuff looks pretty straightforward.
Today,
Yeah,
I did the sheet from them.
yeah. Must have missed barred and that's the arraignment. Appears they kind of lost track of it. She's not in custody.
That's what I'm aware of.
I kind of lost track. It's the whole purpose for the arraignment is they kind of lost track.
Now we're a bunch of sentences.
So that's good.
Morning, detective. I seen something. Mechanical. Yeah. Nice to meet you. I missed your last name.
No, it's like the dirt.
Gotcha.
All right.
All right, so we're on the record in docket. This is 23-04497. People of the state of Michigan versus Joshua Reedy. Will the parties please introduce themselves for the record?
Morning, Your Honor. Andrew Stevens on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Reedy, who is present and seated to my right.
Sir, you are Joshua Reedy?
Yes, sir.
All right, this is the time set for preliminary examination. Mr. Stevens, how are we proceeding?
Your Honor, it's my understanding that we will be running the preliminary examination on this matter.
All right, and are there any preliminary matters to come to the court's attention before we get started from the people?
Only sequestration, which I can handle. I doubt there's going to be an objection to that.
All right, Mr. Milks, any sequestration or any preliminary matters to come to the court's attention before the people start calling their witnesses?
We would just stipulate to the sequestration, Your Honor.
All right, so I'll allow that in. So that'll be the hands of the lawyers. They can let the potential witnesses know that they're sequestered for purposes of this hearing. And then as people come in and out of the courtroom, you can make some similar requests. The only one exempt from that ruling is the investigating officer.
Well, I should have handled this differently. Immediately behind Mr. Milks, the three family members of the victim in this case, Mr. James, they are not eyewitnesses to anything. So I will open that dialogue. I forgot to do that sort of in this conversation, so
Right.
my apologies. Beyond that, I can handle the rest. The three young ladies immediately behind me, I'll have sit in the hallway, and the officers that are to your honor's left in the back, I'll just have go back into the room sort of outside.
All
the
right, so
hallway.
they all may be potential witnesses.
Correct.
All right. Mr. Milks, any comment on that?
Just regarding the family members, was there kind of what were we meant by we're going to be dealing with that, I guess? Is it just, were we planning on calling them or?
No.
anything? Okay, all right.
And they're not eyewitnesses. I just want to make sure there's not an issue on.
I can't foresee one at this time.
All
I
right.
guess is what I'm
All
saying.
right.
I don't foresee one.
So any witness who's not the potential for testimony is not under the sequestration order, but any witness that is a potential for testimony for purposes of the sequestration has to now leave the courtroom, okay? Family members, you do not have to leave. Okay. All right. Are the people at this time ready to call their first witness?
Yes, Your Honor.
You may proceed.
Thank you. People call Officer Donovan Moore.
All right, Officer Moore, I'm gonna have you come up here. You can face me and you can state your first name and your last name and spell your last name for the court reporter.
Donovan Moore, spelled last name is Moore.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thank you. Please have a seat in the witness chair and project for recording purposes. Mr. Stevens, you may proceed.
Thank you, Your Honor. Sir, are you employed?
Yes, I am.
How are you employed?
Police officer for the city of Lansing.
And how long have you been employed as a police officer for the city of Lansing?
Almost 4 years now.
What is your current assignment?
I'm a patrol officer on the road.
And how long have you been assigned as a patrol officer on the road?
Almost 4 years now.
I'm gonna draw your attention to the date of January 7th, 2023. Were you working on that day?
Yes, I was.
All right. And what is your shift as a road patrol officer back in January of 2023?
I work nights, so from 8 o'clock at night to 6 in the morning.
The following day?
Yes.
Okay. On the date of January 7th, 2023, did you have the occasion during your shift to respond to the area in and around 1016 North Cedar Street?
Yes.
Right, 1016 North Cedar, is that within the city of Lansing?
Yes, it is.
Ingham County, state of Michigan?
Yes.
Can you explain to the judge, please, why during your shift on January 7th, 2023, you responded to that specific, around that specific location, please?
Yes. We had a few on caller advised that a male was screaming in the roadway near Center and Adams Street. saying he just got ran over.
And did you ultimately responded to that area?
Yes,
Were you by yourself or were you joined by any other officers?
there were other officers.
In your patrol car, were you by
Oh,
yourself?
no, just by myself.
By yourself, very good. Can you describe that area for me, please, around the 1016 North Cedar?
Yes, this North Cedar goes up one way, so it goes straight up north, and then it's just south of Caesar, East Caesar, East Chavez.
Okay. I'm going to. May I approach this witness?
You may.
Your Honor, there's gonna be no objection to filing. What's the number on that?
1.
All right.
I'm handing you what has been marked as people proposed exhibit 1. I think there's a stipulation.
There's a stipulation.
Okay, so people's exhibit 1 is admitted pursuant to stipulation.
For the record, officer, what are we looking at here in people's 1?
That is where the victim was ran over and then followed some evidence leading to the house. Found the car.
Okay. So is people's 1 a map?
Yes,
And does the map include the area or specifically the address of 1016 North Cedar?
yes, it does.
Okay, and where is that relative or on the map if you can sort of just point it out for us? So that would be bottom right-hand corner.
Bottom hand on the right.
All right, so describe for me, please, what you observed when you responded to the area around 1016 North Cedar on that day during your shift.
I saw tire tracks and mud tracks from a vehicle and also a blood trail leading from where the victim was eastbound on Adams Street towards 1016 North Cedar into the driveway.
Okay. So when you say you saw tire tracks, where were these tire tracks that you saw?
On Adams Street.
Okay. And this blood trail, where was this blood trail that you saw?
In the middle of the Adams Street.
And then did you say you followed the trail to a specific person?
The address 1016 North Cedar.
Very good. So sort of looking, where is Adams Street relative to the address 1016 North Cedar?
Directly across.
Is it this street right here?
Yes.
All right, and so we're looking sort of the bottom, the street that runs left to right across from the bottom third of the page.
Yes.
All right. And after you observed this, what steps did you take?
I saw the car, making sure it was unoccupied to see if anybody was inside the car, that it wasn't. I saw a yellow purse lodged underneath the front bumper of the vehicle. And I was worried just in case, just make sure I preserve that evidence. I moved it closer to the sidewalk in case that I suspect that the subject comes out of the house, 1016 North Cedar. At that point, I started going towards the house because I heard.
Okay. So you referenced a specific vehicle. Where was this vehicle located?
It was the driveway, or the driveway of 1016 North Cedar.
And do you recall anything about make, model, color of the vehicle that you're referencing?
It's a blue Chevy Trax.
Trax is TRAX.
Yes.
Correct. Do you remember the license plate number associated with the specific vehicle? All right. Is that something that if you noted would be in your report?
Yes.
Reviewing your report, would that help refresh your memory as to the specific license plate number for this vehicle you referenced?
Yes.
And reviewing, I think I just asked that, but I can't remember. Reviewing that would help refresh your memory? Yes. All right, sorry. I'm on that first page.
Oh, yep, I'm with you.
All right. Officer, I've underlined a portion of this report. What I want you to do is just review that part to yourself and then look up to me when you're done, okay? Doing that, does that help refresh your memory as to the specific license plate number?
Yes.
And what was the number?
ELP 9340.
Right. And did you have the occasion to run that vehicle in either lien or Secretary of State databases?
Yes.
And what, if anything, did you learn regarding the registered owner of that vehicle?
Came back to a female named Casey Harrison.
Do you remember anything about the weather conditions sort of that day or that during your shift from January 7th, 2023?
Rained that day.
Okay. Anything about the weather conditions that you found noteworthy when you came upon the blue Chevy Trax?
Yeah, so it was also snowing that day too, and the top of the Chevy Trax did not have any snow on it. It was basically clear to look like the vehicle was just driven. And there's the black Jeep that was inside there, that driveway too, had snow. It didn't look like it was being driven at all.
Okay, so I'm gonna back up for a second. If I understand your testimony, there was another vehicle located you observed at 1016 North Cedar?
Yes.
What was the make, model, color of that?
It was a black Jeep.
Okay. And you visually compared the two when you arrived at the scene?
Yes.
And the difference between the blue Trax and the Jeep were what relative to the weather conditions?
One didn't have any snow on it. It was wet, but the snow was basically melting off, and one had snow on it.
Okay, and the blue Trax had the melting snow?
Yes.
And what did you sort of discern from those observations?
I believe that this was the same vehicle that was used in the assault for the victim, and it just drove back, especially with the mud trucks.
And the vehicle was recently driven?
Recently driven.
Let me be more clear. The blue Trax was recently driven. Yes. Are you familiar with an individual name identified as Joshua Reedy?
Yes.
And was that from your contact on January 7th, 2023 or something else?
Also, other times I responded as a police officer for the city of Lansing. I responded.
Objection at this point, Your Honor, going potential other acts.
Just for identification.
Okay, with that understanding, this objection sustained, and give some background as to the identification.
Did you have contact with Mr. Reedy on the date of January 7th, 2020?
Yes, I did.
Okay. And did you have contact with a person name identified as Casey Erickson on that date?
Yes, I did.
Where was the contact with those two individuals?
They were inside of 1016 Cedar.
If you saw Mr. Reedy, would you be able to recognize? Sorry, if you saw Mr. Reedy, would you recognize him?
Yes.
Do you see him in the courtment today?
Yes, sir.
Could you please point him out and describe an article of clothing, please?
In a blue T-shirt and black glasses.
Let the record reflect that Officer Moore has identified the defendant, Mr. Reedy, in this matter.
Any objection to any objection to the witness identifying the defendant for purposes of prelim?
For purposes of prelim, no, Your Honor, no objection.
All right, with that understanding, the witness has identified the defendant.
Thank you, Your Honor. No further questions.
Any cross-examination, Mr. Mills?
Thank you, Your Honor. Officer Moore, you've been an officer for 4 years, is that correct?
Yes.
And part of your duties as an officer is to take photographs of the scene, is that correct?
Yes.
You were the first person to locate the purse that was in the Chevy Trax, is that correct?
Yes.
Did you take a picture of it where it was before you removed it?
No.
Were you wearing gloves when you removed the purse?
No.
Is it impossible that you could contaminate any evidence by not wearing gloves?
I'm sorry, that's possible.
If there's fingerprints on the purse,
Yes.
now your fingerprints would be on the purse, correct?
Yes.
And so it's no longer in its original state after you touched it, correct?
Correct.
It's also no longer in the original state and where it was when you moved it out of its original place, correct?
Correct.
Did you have initial contact with Casey Erickson? Were you the first, I'm sorry, let me back that up. Were you the first person to contact Casey Erickson that evening?
Yes.
What was she wearing at that time?
Black t-shirt, jeans.
And did you contact Mr. Reedy?
Yes.
You were the first person to contact him as well?
Yes.
Remember what he was wearing?
I don't.
You indicated in your report that he was shirtless, is that correct?
That's my point.
Do you recall that or no?
I do.
Did you speak with any of the witnesses, any of the neighbors? I'm sorry.
Yes.
Remember who you spoke with?
Robert and Zachary Jr.
Just for the record, the last name, as you recall, is it M-Y-H-R-E?
Yes.
Thank you, Council.
If you recall, were either of the mirrors, were they able to identify the individual driving the car?
I believe Robert did.
To the best of your knowledge, Robert identified a heavyset female, is that correct?
I'm gonna object to hearsay.
Response?
Just effect on listener, Your Honor, part of his investigation that day to try and figure out what was going on and get the understanding and lay of the land.
Response to effect on the listener.
I don't know how that specific question, maybe the officer can detail how that may have had an effect on him, the specific identification of the person. Otherwise, I think it's sort of the argument is to try and to get a statement of identification that would otherwise be inadmissible in.
But since it's not being offered for the truth, there's no substantive purpose of it. I understand the nature of the question, but I'm going to sustain the objection at this time.
Thank you, Your Honor. So that evening, did you arrest anyone?
Yes.
And who did you arrest?
Casey Erickson.
Okay, so Casey Erickson is the individual you arrested. Is that in part due to an identification made earlier that evening?
Objection, hearsay.
I didn't ask for the actual statement. I just said whether or not that was based on an identification earlier that evening.
But underlying that is a statement of identification, which is not a core statement.
Which we're only using for purposes of he made the arrest, and what is the purpose for that arrest?
I'm not going to use this substantively. This is offered to show why the officer did what they did in their investigation. So it's got an effect on the effect on the listener aspect. I'll allow it. The objection's overruled.
So, sir, was this based on an investigation, or I'm sorry, upon an identification that was made previous to that evening?
Also identification.
Regarding, I want to go back to the purse that you found. Did you look inside the purse?
A little bit, but I find it substantial.
Did you find identification?
Not that I can remember.
You looked inside the purse. Did you take pictures inside the purse before you looked inside?
No.
Did you take pictures while you were looking inside?
Yes.
You did take pictures?
Yes.
You indicated on the street there were tire tracks. Is that correct?
Yes.
There was a set of mud tire tracks, is that right?
Muddy tire tracks.
And there was just one set of muddy tire tracks that led which direction?
East.
So there was one set of muddy tire tracks that led east, is that correct? And when I say one set of tracks, did it look like the vehicle had stopped, backed up on the street and then moved forward again?
Yeah, closer towards the sidewalk on the east side of the street on North Street.
On the actual street though?
No.
Okay, so there was one set that just continued, forward momentum.
Yes.
Thanks, sir. Thank you, Your Honor, for the questions.
Any redirect?
Mr. Muir, Robert Muir, did he say that he observed the female get out of the car?
No, I asked him specifically if he did, and he did not.
Your Honor, I'm sorry. At this point, this is exactly what I was objected to at this point. I couldn't go into this and now the prosecutors seem to open it up at this point.
Response? So it's a hearsay.
I'm sorry, yes, for hearsay purposes.
Well, I don't remember any question where Mr. Milks asked that specific question. He just asked statements of identification as to who he arrested and what statements Mr. Muir asked. And as to the basis of the arrest, that was what Mr. Milks got into. And so I'm just going back into what Mr. Milks opened up as to the questions for this officer.
So what's your hearsay response?
Well, my hearsay response is the same as his response, which was it goes to the effect on the listener. This is a part of the narrative that ultimately this officer used, or the information this officer used to, as Mr. Milks set up, effectuate an arrest on Ms. Erickson. I'm only elaborating as to the additional elements of that narrative that were not addressed by Mr. Milks' line of questioning.
All right, so I'm going to allow the testimony concerning the effect on the listener as to why the investigation continued in the mode it did. That's not being used for substantive purposes, so the objection's overruled.
Thanks, sir.
Did Mr. Robert Muir express during your conversation with him that he saw who was driving the vehicle?
He said he did not.
Okay. And as it relates to this female, what specifically did he say regarding this female and that vehicle?
He knows them. He lives on like the southwest corner, almost directly across from that street, and he knows that the female that he saw lives there. Okay. He knows her driving that vehicle.
Did Mr. Muir indicate he saw who got out of the car as it relates to this January 7th incident?
No.
Did he ever indicate seeing a female near the car that day? Or that, I'm sorry, that around the time that you were present?
Only near the car.
Okay, but not driving and not getting out? No further questions, thank you.
Any cross-examination based on any of those questions asked?
Yes, sir. Just one or two. You also spoke with Zachary Muir, is that correct?
Yes.
Zachary is the individual who actually saw the individual get out of the car?
No.
He's the individual who saw the woman or identified the woman, is that right?
Robert.
Robert identified the woman? Did you indicate in your report that Zachary Muir was the individual who saw the incident occur?
Both people saw the incident occur, different steps.
Both of them saw what actually occurred?
Well, hold on. He said different steps.
Right.
Okay.
What does that mean? Different steps?
One person saw the beginning part of it, and the other person saw, I believe, the midsection part. But no one saw who got in the vehicle. No one saw who got out of the vehicle.
All right. Thank you, officer.
Yes, thank you. No further questions. Thank you, Your Honor.
May this, any redirect or may this witness speak?
No redirect. This without objection. People have believe this witness to be excused.
Mr. Milks, any objection to the witness being excused?
No objection. Thanks, sir.
You're excused from the witness stand. Thank you for your appearance today. The people may call their next witness.
Thank you. People call Officer Jake Ellis.
Right, Officer Ellis, we'll have you stand right here and please state your full name and spell your last name for the record.
Jake Ellis, J-A-K-E-E-L-S.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, please have a seat and project for recording purposes. Mr. Stevens, you may proceed when you're ready.
Thank you, Your Honor.
Officer, are you employed?
Yes,
How are you employed?
the Lansing Police Department,
And how long have you been employed with the Lansing Police Department?
just under 4 years.
Who's your current assignment?
Patrol.
And have you been assigned as in patrol during your entire career with Lansing Police Department?
Yes,
Officer Ellis, I want to direct your attention back to the date, specifically January 7th, 2023. Were you working on that day?
yes.
What is your shift? What was your shift back on that day?
Night shift, so 8:30 p.m. to 6:30 in the morning.
The following morning. So your shift would have started on January 6th and gone into January 7th?
Yes,
And officers, during your shift on January 6th into January 7th, did you have the occasion to respond to a location near 1016 North Cedar Street?
yes.
And can you explain to the judge, please, why you were dispatched to that area during your shift, January 6th into January 7th, please?
You were dispatched to the intersection of Center and Adams for a personal injury accident.
Okay.
Caller described a male in the street screaming. Okay.
When you say personal injury accident, what are we to, what does that mean to you?
Means we're responding to some form of motor vehicle crash where one of the involved parties has injuries of some kind.
Do you recall during your shift, what time you responded to this specific call? Okay, would that, the specific time, would that be something contained within your report?
Yes.
And so reviewing that, would that help refresh your memory as to the time you were dispatched for this particular call? Okay, purchase witness.
May.
I have sort of underlined in blue a portion of your report. If you can review that to yourself and then look up to me when you're done. Reviewing that, does that help refresh your memory as to the specific time you responded to this call during your shift between the 6th and the 7th of January 2023?
Yes.
What was the time?
1:48 hours.
Of what day?
7th of January.
All right, great, thank you. Center, I think you said you went to what area relative to 1016 North Cedar?
Center and Adams is approximately a block and a half, 2 blocks to the west.
Okay. Is that within the city of Lansing?
Yes.
Ingham County, state of Michigan?
Yes.
So. People's One, the map. Is this, you familiar with the area depicted within People's One? And is this the area Center, Adams, and Cedar that we referred to just briefly?
Yes.
And Center and Adams, is that this intersection is sort of the bottom, that's left hand?
Yes.
Left hand side?
Yeah.
Okay. When you responded to that location, were you alone or were you joined by any other officer? or officers?
Yes, I had a recruit officer with me.
So you were yourself and another recruit officer in the same patrol vehicle?
Yes, I was their training officer.
When you arrived at Center and Adams, were you the first? You and your training or the recruit officer, were the two of you the first to arrive at that scene?
Yes.
Could please describe for Judge Flores what you observed upon arriving at the intersection of Center?
I'm sorry. We're getting new people coming in into the courtroom. I just want to verify whether.
Okay, they're all family members.
All right.
Thank you, Mr. Phillips.
Thank you, Brian.
Officer Ellis, if you could please describe what you observed when you first arrived at the intersection of Cedar and Adams on January 7, 2023, please.
Cedar and Adams or Center?
I'm sorry, Center and Adams.
We use the mail lane on Center, but then just north of Adams. Large pool of blood. Usually he was sitting up, and once we approached him, it was very obvious that he had significant injuries.
On that day, were you wearing what is known as a body worn camera?
Yes.
And do you know if your body worn camera was functioning that day?
Yes.
Have you had the opportunity to review or observe any footage that your body worn camera was recording the day you respond, or that day, January 7th, 2023?
Yes.
In fact, is it, and I have what is marked as People's Proposed Exhibit 2. Is People's Proposed Exhibit 2 a flash drive?
Yes.
That I'm holding in my hand?
Yes.
And before we started court today, then you and I have the opportunity to look over the contents of this flash drive.
Yes.
And the contents include footage from your body worn camera from January 7, 2023.
Yes, that's correct.
People move for admission of People's Proposed Exhibit 2.
Any objection to People's Proposed Exhibit 2?
I don't know how we're going to provide it to the court if there's more than one body cam on there.
Just that one.
Just one body camera, then no objection. Your Honor. Thank
Okay,
you.
without objection, People's Exhibit 2 are admitted into evidence.
I have, just one moment.
Okay.
Thank you. Thank you, Judge.
All right.
And Your Honor, for the record, what I did is I informed the family that based on what I anticipate the video that was just admitted, People's 2 will show is of the victim in this matter, family's loved one. I wanted to give them sort of advanced knowledge. That way, if they didn't want to see it, they should exit the courtroom.
All right, thank you. Just so you understand, if it is emotional content, you can't say anything, okay? All right.
Officer, do you see the contents of People's 2 up on the television that's to your left?
Yes, it is.
And there's a date time stamp up in the upper right-hand corner.
Yes.
And I'm going to, although it's only 8 minutes and 36 seconds in total, I'm going to move or begin playing somewhere around the 2-minute mark.
Your Honor, before we go, may I briefly voir dire the witness?
You may.
Thank you. Sir, it looks like, are you in the passenger seat in this?
Yes.
And who's driving?
My recruit officer I have.
Okay. Thank you, Your Honor.
All right. You may proceed, Mr. Stevens.
Thank you, Your Honor.
New message. Incident assigned.
Hey boss man, go and lay down for me.
So where are we right now?
That's the intersection of Center and Adams.
Okay, and what do we see immediately in front of you?
Saw Mr. James sitting in the boardwalk.
Now, did you know Mr. James beforehand?
Prior experience, but it had been some time. I didn't immediately recognize him.
Okay. Did you, as part of this call, identify the individual directly in front of us at this point as Mr. James?
Yes, throughout the investigation.
And how did you do that? You remember?
He's able to locate the wallet in his pocket and that had his ID card in it.
Okay. And just for the record, I paused for this line of questioning with the video at 2 minutes and 19 seconds.
Your Honor, I'm sorry, I'm okay with the video. I'm going to object to any sound that's going to be played during this, Your Honor. It's going to be hearsay without exception at this point.
No objection, and I just muted it.
Thank
All
you.
right. So this is the intersection of Center and Adams, is that correct?
Yes.
Okay.
Describe for the judge, please, what you're observing, what we're seeing here on the body cam as you first arrived and made contact with Mr. James, January 7, 2023, please.
So obviously putting the gloves on, protecting the amount of blood. Trying to figure out who he was, what had possibly had happened. And considering the significant injuries that we observed, we immediately called for the Lansing Fire Department to arrive quickly to get into the hospital, get medical treatment.
Pause. I believe we're pausing at 3 minutes and 14 seconds. So this area looks like immediately above what is your right hand, or one of your hands here. And I'm circling with the mouse. What is this?
That's pool blood.
Okay, and then this area that I'm circling here, what is this?
That's
Do you know what this item is right here that I'm circling?
It's a shoe.
Describe Mr. James's condition when you first arrived and made contact with him, please.
He was unable to really formulate any sentences. Obviously, you can see the road rash and the abrasions on his arm, the blood so everywhere. One of his feet or foot was hanging off and was almost essentially detached from the body.
Okay. I paused here at 3 minutes and 31 seconds. Does this portion of the video depict some of the injuries that you described verbally a second ago?
Yes.
And if you could sort of narrate that for the judge, please. How does this capture some of the injuries that Mr. James was suffering upon your arrival?
You can see on his right hand up to his elbow, that was blood and the abrasions that we could immediately observe.
Describe, if you can, or narrate for us the clothing that Mr. James is wearing as depicted in the body cam footage.
Orange short sleeve t-shirt and dark colored jeans. I believe they were blue jeans. Can't recall. Exactly.
That officer immediately in front of you, who is that?
That is Officer DeBurso.
I'm sorry, could we just get a timestamp?
Oh, yeah, I'm sorry. I think it paused it right about here at 3 minutes and 36 seconds. These initial moments that you're on scene, what ultimately was your goal of being sort of the first to arrive?
Sure that one, we could get him medical treatment quickly with the fire department. They would be the best resource for him to try to get him stabilized. And our secondary goal was try to figure out if we get any information on possible accused, would be a name, description, or vehicle description.
Okay. Mr. Miller. Do you want me to play any further? Ultimately, did LFD arrive at the scene?
Yes.
And their function was to provide medical assistance to Mr. James?
Yes.
Did you end up providing any medical assistance while you were there?
He attempted to give Stern a rubs. At one point, he started to lose consciousness. Just tried to keep him semi-awake and alert.
Okay.
Once the fire department arrived on scene, they quickly did a low and go and took him to Sparrow Hospital.
Okay, load and go, meaning they loaded Mr. James up in whatever vehicle and took him to the hospital.
Yes, they immediately put him on the cot and get him to the hospital instead of stabilizing.
As part of your response and work on this case, did you ultimately photograph some evidence relative to this call?
Yes.
We'll stipulate to these photos coming as well.
Okay, pursuant to stipulation,
People's
People's Exhibits 3, 4, and 5.
Correct.
Okay. They're admitted into evidence.
Thank you, Your Honor. So I'm going to show you People's 3. Did you take that? You took this photograph?
Yes.
All right. What is depicted in People's 3?
That's the location that Mr. James had been.
All right. And what specifically were you documenting in this photograph?
Show the radius and area of how large the pool was.
All right. And so that this is effectively the same pool of blood that we saw, at least depicted in part, with the body cam footage a moment ago.
Yes.
People's 4. What are we looking at in People's 4?
That is Mr. James' license that there's any friendly on the blog.
All right. And that's how you were able to identify the person that you made contact with on the body worn camera footage as Mr. James.
Yes.
And now People's 5. What are we looking at in People's 5?
That was Mr. James' shirt that they had cut off the gum that we collected from evidence, like from Sparrow, that depicted what appeared to me at the time to be tire treacherous.
Based on observation, did it appear his shirt had any blood on it as well?
Yes.
Thank you, Aaron. Further questions?
Any cross-examination of the witness, Mr. Mills?
Do you want any minutes?
Okay, thank you. Officer Ellis, were you, when you arrived on scene, was Officer Moore already there?
No.
So you were the first person on scene?
Yes.
Thank you, sir. No further questions.
Any objection to the witness being excused from the people?
None, Your Honor. Thank you.
Any objection, Mr. Mills?
No, sir. Thanks.
Okay, witness, you may leave the witness chair. Thank you for your appearance today. And you may call your next witness, Mr. Stevens.
Thank you, Your Honor. People call Officer Sam here now.
Counselor Fear, now I'm going to have you stand right up in front of me. Please state your name and spell your last name for the record.
Sam Fearnow, Fearnow.
All right. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right. Thank you. Please have a seat there and project for recording purposes. When you're ready, Mr. Stevens.
Thank you, Your Honor. Sir, are you employed?
Yes, I am.
How are you employed?
With the City of Lansing Police Department,
How long have you been employed with the City of Lansing Police Department?
about 10 years.
What is your current assignment?
I am assigned to the Crime Scene Investigation Unit,
And how long have you been so assigned?
3 years.
Officer Fiona, I want to direct your attention to the beginning of January of 2023. Did you have the occasion to be involved with an investigation centered around an individual that was injured, name identified as Jesse James?
Yes, I was.
Okay. What was your first involvement in the case regarding Mr. James?
On January 10th, I responded to Sparrow Hospital to take photographs of the victim, Mr. James.
Oh, thank you. Okay, and approach this witness.
You may.
I'm handing you what has been marked as people's proposed exhibits 6, 7, 8, and 9. You could look through those for me, please. You recognize those 4 items?
Yes, I do.
You recognize them as photographs?
Yes.
Are they photographs that you took?
Yes, they are.
Are they the photographs of Mr. James at Sparrow Hospital?
Yes.
Are they a true, fair, and accurate representation of what you saw on January 10, 2023?
Yes, they are.
People move for admission, people propose 6 through 9.
Any objection to people 6 through 9?
Your Honor, my only objection would just be that this is cumulative evidence at this point. The courts, to my understanding, that these are going to be the photos of just the injuries here. The court's already seen the scene itself, and these are just duplicative at this point, just showing additional injuries. Your Honor, there's it's already been shown.
All right, thank you. With that understanding, the foundation's been laid for people's exhibits 6 through 9, and they'll be admitted into evidence.
Thank you, Your Honor. Could you describe for the judge, please, what you've depicted here in People's 6?
This is a photo of Mr. James lying on he was in a chair propped up at this point. We can see the injuries to his face, arms, hands, and shoulder area.
So sort of a general view, essentially from waist up.
Yes.
I'm going to show you now People's 7. What are you looking at in 7?
It's a photo of Mr. James' legs. You can see his right leg is very heavily bandaged, covering his injuries.
And so you're effectively documenting injuries from the knees down.
Correct.
People's 8.
A photo of Mr. James' face and his injuries.
This would be a close-up of some of the injuries observed in People's 6. Is that fair?
Yes.
And then People's 9.
That's a photo of Mr. James' head from the left side of his face.
So a more specific or different angle of the injury that we see in People's 8, but in People's 9.
Correct.
In addition to photographing Mr. James, do you have another role as it relates to this particular investigation?
Yes, I processed a vehicle that was related to this incident.
Okay. Do you recall what day you processed that vehicle?
I believe it was the 11th
of January?
January, yes.
2023?
Correct.
Do you recall the make, model, color of that vehicle?
It was a blue Chevy Trax.
And if you could, under what legal authority did you process this particular vehicle?
Detective Martha McGonigal obtained a search warrant for this vehicle, which she sent to me.
Okay, relative to this investigation?
Correct.
All right. And what is the general process that you go through when you process a vehicle pursuant to a search warrant for any particular investigation?
Yep. So the first thing we do is take photographs. We do overall photographs of the entire vehicle from the outside, every side, front and back, and every corner. Then we open up the vehicle and photograph the inside, anything in the door pockets, anything in the center console, glove box, anything you can see. Then we go through and look for anything relevant to the case we're investigating. So in this case, it was a hit and run vehicle crash. So I'm looking for blood, damage to the vehicle, anything that can tie the victim to the vehicle itself.
As to this vehicle, did you follow the steps that you sort of described a moment ago?
Yes, I did.
All right, and I'm going to show you what has been marked with people's 10, 11, 12, 13, and 14. If you could review those for me, please, and just look up to me when you're done.
Yeah, we would stipulate these photos.
Thank you.
So pursuant to stipulation, people's exhibits 10 through 14 are admitted.
Thank you, Anna. Thank you, Mr. Mills. So people's 10, what are we looking at here in people's 10?
This is a photo of the back corner of that blue Chevy Trax we just talked about.
Okay, and why do you take a picture of the backside?
To document every side of the vehicle, any damage that might be there, and also so we can see the license plate from the back of the vehicle.
The license plate of the vehicle is what?
Edward Lincoln Paul 9340.
So ELP 9340.
Correct.
Now, when you process this Chevy Trax, can you describe for the judge what steps you took to describe or to process this particular vehicle?
So again, we took photographs. In this case, we're also trying to identify who was driving the vehicle. So I collected some DNA from the steering wheel and driver's area. I looked for blood, any other evidence. This was also described as a hit and run where the victim may have been dragged underneath the vehicle. So in this case, I also placed the vehicle on our hoist, lifted it up so we could do a better examination of the undercarriage of the vehicle.
Okay. People's 11, is that what is depicted here?
Yes, the vehicle on the hoist.
And what, if anything, do you remember discovering underneath that blue Chevrolet Trax?
Yes, there was damage to the undercarriage, pieces of plastic that were broken out, areas of the frame that had a more polished appearance, like something had rubbed underneath it or been dragged against it. We also found several areas of suspected blood and some orange fibers that I suspect came from the victim's clothing.
Your Honor, I'm sorry, just part of the testimony, there's some suggestion or at least some speculation at this point without foundation. Probably knows this as well and is coming to some conclusions in the matter here. I would just object to his testimony to what you just said.
Response?
I think I will get there. So to the extent Mr. Milks wants to either strike a portion or not, I understand, I think, what he's going after, and I anticipate getting to address some of that. So
Yeah, with that understanding, any identification of the blood, what right now we found is the blood and the evidence concerning an investigation of the bottom of the vehicle, and we'll leave it at that until we identify each remnant. So with that understanding, the objection sustained.
So I'm going to show you what has been received as People's 12. Can you describe for the judge, please, what we're looking at in People's 12?
Yes, this is some blood spatter I found on the undercarriage of the vehicle. It was on the aluminum heat shielding around the gas tank.
Okay, and so in this picture, I see an orange sort of triangle that comes to a point and what looks like a ruler. Is that correct?
Yes, I placed the orange triangle so we can see exactly what I'm trying to get in the photograph, this red spot. And then the ruler is just to give scale.
Okay. So now I'm going to show you what has been received as People's 13. What are we looking at People's 13, please?
This is that same red spot we saw in the previous photograph. Here I've used a hemostix. It's a presumptive test for blood. What it is you take a swab of that red substance and place it on the testing strip. And if it reacts by turning dark green, that means it's indicative of blood.
Okay. And then now I'm gonna show you what has been received as People's 14. What are we looking at in People's 14?
This is an orange fiber. I found stuck to a piece of black plastic on the undercarriage of this vehicle.
Okay. Now, when you go into and you process any particular evidence on any particular case, do you receive some information before you go in, or do you do this blind?
I receive information. Yes.
Okay. And why is it you receive some information before you process an item?
It's important to know details about the incident so I can know what I'm looking for, how to direct my investigation, things I might want to process for, and what to look for.
So People's 14, this orange fiber, why did that stick out to you as you processed the blue Chevy Trax?
Because I had previously looked at photographs of clothing that was collected from the victim by road patrol officers, and I had seen an orange shirt that the victim had been wearing, and black marks on it that appeared to look to me like tire marks.
So I'm gonna show you People's 5. Is that sort of what you're referring to?
Yes, that's the photograph I saw.
Now, to be clear, do you know if that orange fiber came from that same clothing item that was depicted in 5?
No, I don't know that.
But it's something that caught your attention?
Correct.
All right. Thank you, Your Honor. No further questions.
Cross-examination, Mr. Mills.
Thank you, Your Honor. So, no, Your Honor, no questions. Thank you.
With that understanding, may this witness be excused from the people?
Without objection. Thank you.
Mr. Milks, any objection?
No objection.
Witness, you're excused. Thank you for your appearance tonight.
Thank you.
And Mr. Stevens, you may call your next witness.
Thank you. People called Detective Martha McGonigal.
Please state your name and spell your last name for the record.
Martha McGonigal, McGonegal.
All right, please raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I will.
Right, thank you. Please have a seat and project for recording purposes. Mr. Stevens, you may proceed.
Thank you, Your Honor. Ma'am, are you employed?
I am.
How are you employed?
I'm employed by the City of Lansing Police Department as a detective.
How long have you been assigned as a detective for the City of Lansing Police Department?
7 years.
How long have you been a sworn officer for the City of Lansing?
20 years.
And as a detective, are you assigned any particular subset of cases?
I am. I'm currently assigned to the Major Crime/Violent Crime Division of the Detective Bureau.
In the early part of January 2023, were you assigned an investigation into an incident involving a suspected victim name identified as Jesse Lamont James?
I was.
When did, if you recall, when were you assigned that specific investigation?
It was on the 7th of January. I believe I was called between 7 and 8 a.m.
And when you are called and assigned a specific case, what are some of the first steps that you take as a detective?
Looking over the general information is typically the first thing. Then I read over road patrol officer reports and interview both suspects, victims, and witnesses.
Okay. Why is it that some of the first steps you take is to review, road patrol and other reports?
I don't have the luxury of being there firsthand when I'm called quite a bit after the fact.
Okay.
So just kind of to see what the first responding officer saw when they arrived.
Okay. And from that information, do your investigations, this one or and other, go in various directions based on what you learned sort of initially?
Correct, they do.
Now, I referenced a moment ago an individual name identified as Jesse Lamont James. What connection, or I'm sorry, did you learn his connection sort of in the initial part of getting this investigation assigned to you?
Yes,
And was that through some of those initial reports?
correct.
Did you have or make attempts to contact or communicate with Mr. James after receiving this investigation as an assignment?
Yes, I did.
Where was Mr. James when you tried to contact him?
I don't recall the specific floor, but he was located at Sparrow Hospital in a critical care unit.
Do you recall when you first tried to make contact with Mr. James after receiving this investigation?
So my understanding was that his injuries were substantial on the 7th when I first came in to speak with him. So I contacted nursing staff on that particular floor to see if he was capable of speaking with me. At that time, he was not.
Did you, on the 7th, did you, am I to understand then that you did not even speak with or see Mr. James on the 7th?
Correct.
How many times thereafter did you attempt to make contact with Mr. James relative to this investigation?
I made a similar phone call again on the 8th and received the same information. He was still intubated and unable to speak to me. On the 9th, I went to the hospital for the first time, at which point he was not able to speak with me due to his level of medication. I went again on the 10th, at which point he was not available because he was in surgery at that time. I again went on the 11th with a similar explanation as to where he was, so I was unable to talk with him. On the 12th, I went. He was heavily medicated, but he was able to make very brief statements that were mostly coherent. And then on the 13th, we were able to have a very coherent conversation.
All right, so the first time you were able to actually speak with Mr. James in what you described as a coherent conversation was January 13th of 2020.
Correct.
Showing you People's 6. Do you recognize that to be Mr. James?
Yes, I do.
All right. Now, when you, whether he was in this condition or not, let me ask it this way. The first time you were able to actually see Mr. James in person, was he in a condition similar to what is depicted in this photograph?
He was. He had some pretty severe bandaging going around his face at the first time he and I had face-to-face contact with each other.
Okay. And then when you ultimately spoke with him on the 13th, was he in a similar condition as depicted in People's 6?
He was.
Okay. Each time that you went to speak with him leading up to the 13th, was he in the same, I think you said he was critical care on the 7th, did he remain in the same, I guess, ward or floor or department? I don't know how to characterize it all the way up to the 13th.
Yes, he was still in an intensive care unit.
During your investigation, did you have the opportunity to speak with a person name identified as Joshua Reedy?
I did.
Would you recognize Mr. Reedy if you saw him again?
I would.
You see him in the courtroom today?
I do.
All right. Could you please point him out and describe an article of clothing, please?
Sure. He's seated to what is my left-hand side with brown hair, wearing dark glasses and a blue jumpsuit.
Your Honor, let the record reflect that Detective McGonigal has identified the defendant in this matter.
Any objection from the defense?
No objections.
Without objection, for preliminary examination purposes, the witness has identified the defendant.
You have an opportunity to specifically interview Mr. Reedy relative to this investigation.
We never had a conversation about his involvement in this case.
Okay. But you did have at least some, did you at least have some face-to-face contact with Mr. Reedy as you were working the investigation of this case?
I did.
Detective, I'd like to sort of briefly discuss the course of this investigation. into the events that sort of surrounded the injuries associated with Mr. James, okay? Did there come a point where somebody was initially arrested regarding and suspected to have caused the injuries to Mr. James?
Yes,
Who was that person?
Casey Erickson,
Okay, do you know when she was arrested?
into the early morning hours of January 7th. I don't know the specific time.
You know if Ms. Erickson was charged ultimately with causing the injury surrounding Mr. James?
She was formally charged, yes.
Did there come a point where, based on your investigation, you believe that those charges should not stand against Ms. Erickson?
Absolutely, yes.
How did you come to that conclusion?
Both because the
Objection,
investigation,
Your Honor, at this point, it's such a broad question. It's going to incorporate hearsay, it's going to incorporate parts of her investigation. It's so broad at this point. It's going to incorporate multiple forms of hearsay.
Response?
I guess if Mr. Mooks doesn't want to get into it, I don't need to get into it either, so I'll move
right.
on.
All right, so the objection sustained for our purposes, and Mr. Stevens, you may proceed.
Thank you, Your Honor. Did there come a point where Mr. Reedy became the subject of your investigation?
yes,
And was this as your investigation continued even beyond the arrest of Ms. Erickson?
yes.
Beyond sort of your initial steps, if you could please describe for Judge Flores, what types of other information or evidence did you seek as part of your investigation into who may have caused the injuries to Mr. James?
Sure. So one of the things that happened was we did a neighborhood canvas by walking door to door and looking for video cameras affixed to homes in that area, hoping that someone would have a better depiction of what actually took place, perhaps even who was driving the car. Another thing that happened was we learned that the house directly 2 houses north on the same side of the street did in fact have cameras. It was pointed out that those cameras also have audio. A search warrant was obtained for that house and it was attempted to secure that video. Although the search warrant was essentially unsuccessful in obtaining that video, the homeowner there did allow me to look through his visual on that video, in which I could see in both.
Objection, Your Honor. She's discussing something at this point that I believe we don't have evidence for at this point.
I think she's describing her personal observations, so that her sworn testimony would be the evidence.
Right, so what's the legal objection, Mr. Mose?
Just at this point, I would just say lack of foundation because she hasn't actually seeing what the camera is depicting at this point. She's watching the camera, but she doesn't have personal knowledge of what that was actually depicting. There's been no foundation regarding the day that she was observing this, not the day that she was observing this, the day that it's depicting, so to speak. So at least for lack of foundation at this point, Your Honor.
Response, Mr. Stevens.
I think that's exactly what the detective was. Unless I sort of was understanding her testimony differently, I think that's exactly what she was narrating, is what she saw, when she saw it, what it was depicting, date and time, and we just hadn't gotten to that point.
Right. So I'm gonna overrule the objection, allow the witness to testify as to what's the date and time of what she's perceiving on the video based on her personal knowledge. I don't think she can testify to anything she heard, but I think she can testify to what she saw.
Yeah.
Well, I would object to the date and time being on there because that would be a written assertion, Your Honor, for the truth of the matter asserted in this situation. So the date and time I would object to.
Hearsay doesn't apply to mechanical devices like a camera. So it doesn't.
I think she can indicate what she sees in regards to a timestamp.
I would just keep my objection.
Okay, all right. With that understanding, the objection is overruled and the witness may proceed.
Go ahead.
I lost track of where I was at in narrating that event.
So I asked regarding some of the additional evidence, and I think where we left off, you were describing a search warrant for surveillance video that you were able to personally observe, but unable to actually save pursuant to that warrant. Does that sort of hopefully get you back on track?
It does.
Okay.
So A search warrant was obtained for 1022 North Cedar Street, which is 2 houses to the north of 1016 and on the same side of the road. The time at which we went to that residence, the homeowner there allowed me to look through his cell phone because that was the way that he was able to look through videos. He let me scroll through it for, I was there probably 25, 30 minutes. He let me scroll through it until I got to the date of January 1st. I knew the timestamp that I needed because the police were initially called at 1:48 a.m. So I went to a time frame shortly before that and began to look through the videos that were captured on his surveillance.
Okay. And what, if anything, did you observe that sort of advanced your investigation?
So a female who I believe to be Casey Erickson ran up the driveway that is shared between 1018 and 1022. They have a shared driveway between them. I could observe a female. I believed it to be Casey, but again, I'm looking at a cell phone that's relatively small.
Okay.
There's loud conversation. I can't make out what's being said, but I can hear voices.
Okay.
In the next video, these videos are like a few seconds in length each. The next video, there's 2 male voices. Again, what they're saying can't be made out, but it doesn't sound friendly. They're yelling. And then the third video is you're able to see headlights turn on. You can see the headlights get further away as though something is backing up. And then you see the headlights again turn to what would then be the west. And you see a vehicle corresponding with those headlights take off westbound. You can see just the headlights, and that's really all you can tell. You can tell that it's a smaller SUV or a 4-door sedan type vehicle. And then the next video is what appears to be the exact same video coming from west to east of Adams Street and disappears out of the camera view to the south. And then the headlights go dark.
Okay. You referenced voices. I think you said, you testified, you couldn't make out what was being said. Were you able to discern male, female at all, or is it not clear enough?
The first video where it appears to be Casey walking, it's a male and a female voice. The second video is 2 males.
Okay. And that second video, is that connected or in close proximity to this vehicle that you're referencing?
Yes, it is. It's the same space. It's kind of off of what you can see on the video, but the videos have wonderful audio for it to pick up 2 houses, essentially south residents.
Absent what specific words are being said?
Correct.
All right. Beyond surveillance video, was there other information that you took steps to obtain, or evidence you took steps to obtain as part of this investigation?
There was one witness that came forward initially, and then I obtained search warrants for Facebook, or actually it's referred to as Meta Platforms, but we all know it as Facebook. The company actual name is Meta Platforms.
So you said there was a witness that came forward, and then you also acquired social media evidence.
Correct.
Is that maybe a better way without getting into the nuance of Facebook versus Meta?
Yes.
Okay. Was the contact with the witness what prompted you to seek out and obtain social media? Was it something that you planned to do or something else?
Objection, Your Honor. This is just based on hearsay. Mr. Stevens is very craftily just trying to get around the hearsay and just essentially using that the hearsay evidence in order to figure out where she's going next, which provides us the opportunity to cross-examine anyone in the situation. But essentially, this is all based on hearsay, Your Honor. I think it's pretty clear from how he's asking his questions.
Response?
I didn't ask what the witness said. I was asking if the witness prompted this detective to then get social media, if she was going to get social media irregardless of, I guess I would admit it was a compound question in a sense, so I could break those up, but I didn't ask what the witness said at all.
I didn't hear all I heard was, why did you do this investigation in this way? I'm not, for our purposes, I'm not taking it any as offered for the truth. I'm taking it as to why she did what she did in the case. But I would have the people break down each question so that we understand, did she do it on her own? Did she do it because somebody said something, and then we can entertain an objection in that space. So the objection at this time is sustained, and I'll allow you to rephrase some questions.
Perfect, thank you. You referenced an eyewitness, and you also referenced obtaining social media evidence. was the interview you had with the eyewitness connected to the social media?
No, those accounts had already been preserved through the Facebook application so that they could have a search warrant drafted for them prior to the witness coming forward.
Okay, so the witness didn't necessarily lead you to obtaining social media.
Not at all.
All right. Now let's move then to the social media evidence. What sort of social media evidence did you obtain in this case?
So I wrote a search warrant for Meta platforms, which again is what we know as Facebook. It's a very common social media application in which it can be used to share pictures, but also for the purpose of communication with only Wi-Fi through the Messenger application.
Okay. And specifically, did you request social media evidence pertaining to the person name identified as Joshua Reedy?
I did.
If you could please walk through what are the steps in order to obtain social media evidence as it relates to this defendant, Mr. Reedy.
So once I obtained a search warrant signed by a judge, I uploaded that warrant to the Facebook platform for law enforcement, in which I essentially send them the search warrant. They gather the information. They then notify me through the same law enforcement portal that the information requested is available for me to download.
Okay.
At which point I did download that information along with the information they send back. Typically, it includes a
Objection, Your Honor. This is going to be hearsay. All the information she's getting at this point from Facebook, this is going to be hearsay evidence. Essentially, I don't believe she's laid a foundation that she is the records keeper at this point.
Well, again, unless
response?
Unless I am so off the mark as to what I think the detective is testifying to, I think she's going to be describing exactly what she received from Facebook, not the contents. But all of that is necessary foundation to admit certain pieces of evidence. So again, only the detective can really speak to that, but that's where I was going with the question, and that's, I think, where she was going with
I
the
don't
answer.
think this is objectionable at this point. I think that witness can indicate what Facebook gave her and the steps that led to that. Information inside those exhibits, that's different. But I think the witness can testify as to what was given to her by Facebook.
And I can appreciate that, Your Honor, and I guess it's more preemptive on my end. If there's going to be specific statements within this data, that's essentially what they're coming down to, is statements, I believe, found within this data download, essentially. So I guess it's a preemptive objection. I appreciate what the court just said, so I probably will renew my objection here shortly.
All right, so with that understanding, the objection's overruled, and you may proceed as to the contents that was downloaded from Facebook.
Thank you.
So Facebook sends a downloadable application essentially. With that is also a form of authenticity that comes from their custodian of records. It's signed, and I believe it's even notarized, as the person that's sending that information authenticates that it is a real and true form of what their social media application holds as the user's information.
And so you received that on this particular case.
Yes, I did.
As it relates to the requested information for Mr. Reedy and his social media records maintained by Meta.
Correct.
And
What is on? Yeah. Okay.
I understand, and I'm not going to do giving you.
Okay. Okay.
At least Facebook. It's content, but even- So, yeah.
Okay. I understand.
I just wanted-
No, I appreciate that. Yeah, can we just approach briefly, Your Honor?
So,
Large to small.
all right, so we've had a conference or a bench meeting, and Mr. Milks, did you want to make a record concerning anything that was indicated, and then I'll have Mr. Stevens respond.
Yes, Your Honor, thank you. It's my understanding that people wish to introduce what's colloquially known, I believe, is just a data dump regarding the Facebook. For purposes of prelim today, I understand it's going to be coming under, it's got the sign authentication, business record, Your Honor. There's also no Sixth Amendment right that is a trial right, so we wouldn't have any sort of Sixth Amendment claim there. I'm just here making my record, and I just wanted some clarification, which Mr. Stevens did, just for purposes of the prelim today, about what is going to be coming in here.
Thank you. And Mr. Stevens, any response? There was indication that this is an authenticated document. It is a business record document kept by Facebook in regards to downloading from the detective. And then anything else, any other thing else you wanted to make as a record?
Thank you, Your Honor. Mr. Milks has largely covered what I'm sort of moving towards. What I have marked right now is People's Proposed Exhibit 15. Specifically, People's Proposed Exhibit 15 is a flash drive, because I was about to get into with the detective that, in essence, what she receives is electronic data from Meta or Facebook pursuant to the search warrant. But included with that digital evidence is the data requested of a user or users' Facebook records, but also included in accompanying it from Facebook is a certificate of authenticity of domestic records of regularly conducted activity, tough word, which would satisfy 902.11. It certainly satisfies the statute 76611B for preliminary examination. And so in essence, what I'm at this point laying the groundwork for is a business record pursuant to rules 902 and 803 for admission. And then from there, I plan to lay additional foundation that this specific digital evidence that I have is directly associated and connected with the defendant, and move from that point forward. I recognize that Mr. Milks, and he is accurate that this digital evidence contains a number of statements which truly fit the essence of the hearsay definition, but because they're contained within a business record, an authenticated, a certified business record, those fit the hearsay exception. And so while some of these statements are the defendant's and exempted from the hearsay rule, some of them are not, but fit within another exception. And so I hope that I have sort of laid where I'm going. I know some of that foundation has come in, and some of it I intend to elicit a little bit further as we move forward.
All right. With that understanding of what was discussed in the record, you may proceed. I'll entertain any more objections, but I know we're in the room, we are in the realm of foundation being laid is that a business document, and then the other hearsay statements that are inside of that business document, so to speak. And then there's some opposing party statements, is my understanding.
Just for expediency purposes, Your Honor, it would just be my understanding, this is only coming in for purposes of preliminary examination. I guess I would, if it could speed anything up, I'm just objecting if this would be part of trial. Purposes of prelim today, I guess I'm not objecting.
All right, so for purposes of prelim, we have a stipulation as number 15, but only for prelim purposes, not for trial purposes.
I appreciate the stipulation. I would also, as I referenced the statute 76611B, I think the way the statute's even written, I don't even need to lay foundation as to authentication or hearsay. I could have just jumped in.
Right.
Nevertheless, I'm trying to sort of build the record, and I appreciate that, Mr. Miller.
Thank you.
Thank you.
So I guess with that understanding, what I've identified as People's Proposed 15 is received at this point.
It is. All right, so People's Exhibit 15 is admitted pursuant to stipulation.
Detective, I'm holding up two different items. So the sticker is on People's 15. That is just a flash drive, correct?
Yes.
All right, and why, when you receive information from Facebook, why is it placed on sort of a storage device like a flash drive?
I can't send my computer to everyone that needs to see it.
Right.
So once it's downloaded, it's placed on a flash drive for the ease of sharing it with the necessary parties.
Okay, and then in my hand, I'm holding a single sheet of paper that sort of accompanies or was included with People's 15. Is that accurate?
Yes, it is.
All right, and is that the certificate of authenticity regarding the business records that you were referring to a moment ago?
Yes, it is.
All right, and it actually has in paragraph 2 a specific identifier at the end to associate its authenticity as to the evidence you received?
Correct. The number at the end of the paragraph you pointed out is the Facebook ID number. Every Facebook account has one of those unique numbers.
Okay. With that, I plan to display some of this on and present some of this on the TV.
All right, this is People's Exhibit 15.
Correct. How is it that you can view, or how do you view the digital evidence you received from Facebook?
So when it comes from Facebook, it comes in both a PDF and a zip drive. One of the things that I typically do is ask one of our analysts to convert it to a program called Cellbrite, just because it makes things easier and more searchable. It's a lot more user friendly than the way that Facebook returns it. Once it's in Cellbrite, it's unable to be changed in any way.
And viewing it in Cellbrite, does that allow you to, or allow other users, say for myself or Mr. Milks, to view that evidence?
Yes.
Upon receipt of this evidence pertaining to Mr. Reedy, did you have the opportunity to view the social media evidence that you obtained pursuant to your search warrant?
I did.
And did you make observations as to the digital evidence that you received contained in People's 15 that that you concluded was associated with the defendant here in the courtroom?
Yes.
Okay, how is it that you were able to discern that the digital evidence from Facebook was connected with this specific defendant, Mr. Reedy, here today?
So in addition
Here, I'm
to,
sorry, Nate, I'm going to object regarding this information here that she's about to discuss. I know we just did a stipulation. May I voir dire one or two questions?
You may.
Thank you. Detective, you said that you used the Cellbrite, is that correct?
correct.
Does that alter or change the information that comes from Facebook?
It does not. It just puts it in a more searchable format.
Okay, but it doesn't amend any of the information within
It
that.
does not.
And are you familiar with Cellbrite are you familiar with the program Cellbrite?
As a user, yes.
You couldn't do you understand how it changes the data or how it changes things to make it more searchable?
I don't. It's a different application than the way that Facebook returns it. That's my understanding of the difference. It just makes it searchable. It's easier to use.
Put the Facebook data in and it comes out it looks the exact same?
It looks different. It's in the Cellbrite format.
Okay. So the data does look different. So it does change it.
The format changes. The data itself does not change.
There's thousands and thousands of PDF pages. Is that fair to say?
Yes.
Do you go through each and every single page to verify the fact that nothing's been changed?
I know that Cellbrite, as only being a user for Cellbrite, once a Facebook download is put into Cellbrite, it changes nothing about the data.
Okay. Your working knowledge of Cellbrite is only as a user of it.
Correct. I can't tell you how or why. I don't know.
Thank you. Your Honor, I'm sorry, I would have to renew my objection here regarding this information coming in. This is no longer just business records. There has been an actual change to the data itself. It's no longer the raw data that has come through. So I would object to this coming in. It wouldn't work under the business records section because there has been a change made to the document itself. The detective has a working knowledge of the program, not a fundamental understanding of how it works, what changes, and what effect that may have on the evidence here.
Response, Mr. Stevens.
Well, I disagree because I think the detective testified to the contrary. But if the court needs further foundation, I think there are some additional questions that could be asked of this detective that could ultimately help on this issue. So I'll defer to the court.
The court is satisfied that the data has not been changed. The format has been, there's a change in format concerning accessibility and detailed user information in regards to search purposes, but the actual data has not been changed. And therefore, I'm going to overrule the objection.
Thank you, Your Honor.
Thank you.
So I'm gonna sort of dovetail off of what Mr. Milks was asking. The Cellbrite, that program make viewing the data more user friendly.
Yes,
Okay. So for instance, I'm gonna bring up and show People's 15 on the screen. Is this the Cellbrite, what you know as the Cellbrite platform?
yes, it is.
All right, and to the bottom right, under the heading content, is the content subdivided into different categories?
It is. You can reach that same place also by going to the analyzer data that's on the left-hand far right. I'm
So you're
sorry, the
talking
far
about-
left column there.
You're talking about these?
Correct.
Okay.
It breaks it down in a similar way by category.
So if you looked at the raw data from Facebook, you can find everything that is there. Cellbrite simply breaks it up into different subcategories for you.
Correct. When it comes from Facebook, it's a PDF of thousands of pages typically, and it's just one thing after another. Nothing is categorized. So you have to literally look through every single message on thousands of pages and try and make sense of it that way.
Okay, so by clicking on the user account, Cellbrite brings us to the raw data that was provided by Facebook that is applicable to the user account from Facebook.
Yes.
And specifically on the right-hand side, the column has further details regarding the name, Facebook identifiers, and the like. Is that correct?
It does.
All right, so under the heading on the right-hand column, user account, what is the name?
Josh Reedy.
And what is the username?
Josh period Reedy. I believe there's a period and then the number 372, but my eyes are old and that's really far away.
All right, and then below that is there the Facebook identifier. I know that. So under other entries, are there headings for Facebook ID?
There is. It's a number that's associated specifically to Mr. Reedy's Facebook account.
All right, what are the last four?
2089.
And is that associated with the certificate of authenticity that I just handed you and you provided from Meta?
Yes, it is.
So going back to the Cellbrite, there's a grouping entitled chats. Is that correct?
Yes.
If we click on chats, what does that take us to?
So that is what Facebook or Meta saves as messenger conversations once it's converted into the Cellbrite.
All right, and right now, under chats, there is one row that is highlighted. Is that accurate?
Yes,
And that's identified as row number 1.
it is.
And then if we move to the left, it indicates based on the Facebook data, Cellbrite has told us who is participating in this chat. Is that accurate?
Yes.
And then if we move all the way to the right, under the column chat, it actually shows us what we know to be the exchanged messages among the participants. Is that accurate?
Yes.
I'm going to move to row 31. You see row 31 highlighted?
I do.
Okay. Who are the participants of that chat?
Holly Ramiro and Josh Reedy.
Okay, so Josh Reedy, the defendant,
Correct.
and then Holly Romero. Did you come to learn the association of Ms. Romero to Mr. Reedy?
I did.
And how are those two individuals related?
He makes reference to her as his sister.
Okay. And similar to what we discussed on column 1, if we move all the way to the right across the screen, does Cellbrite depict the chat communications, the exchange of messages between Mr. Romero and, I'm sorry, Ms. Romero and Mr. Reedy.
It does.
And that is sort of noted by the blue and the green sort of bubble messages that we're sort of accustomed to with text messaging.
Yes, it goes so far as to if a message is deleted, it shows that with a little trash bin next to the far left-hand side where the check mark is. I'm sorry, on the right-hand column on the far left.
And you had the opportunity to review. Well, let me ask you, did you review this chat exchange between Ms. Romero and Mr. Reedy
I did.
as it relates to your investigation?
Your Honor, I'm gonna object at this point to relevance. This is from January 2nd. At this point, I don't see the relevance for something that happened like 5 days before the incident.
Response?
While I certainly agree that I'm not pointing out anything specific as to the second, my question was simply, did she review this chat communication as it relates to her investigation? I can notify, or I can sort of tell this court and Mr. Milks, I'm not getting into anything regarding January 2nd in just a moment. Assuming I get the answer that I think I did, I intend to be moving forward in time to a more relevant time period, specifically January 7th of 2023.
And so this is in regards to laying foundation for who it belongs to in the association.
Correct. And then simply, I mean, I can't ask the detective questions about the content if she never actually reviewed the content.
Right.
So that's why I asked, had she actually reviewed this chat exchange?
Right. So I'll allow the testimony in regards to foundation for the actual date that is relevant in this matter. So you may continue.
Thank you.
Yes, the objection's overruled.
Thank you, Your Honor.
And I would just note, for the purposes of, and sort of consistent with some of the concerns that Mr. Milks has expressed, I'm going to be moving through the exhibit, but I'm attached it from the video feed, so this court isn't necessarily distracted by some of the things that may be in it.
I'm gonna look over your screen.
No, yeah.
Just so the record's clear, Your Honor, Mr. Stevens going through some of the conversations and allowing me to look over while he's doing this.
So I have moved, I'm still on, or still have highlighted chat number 31. Is that accurate?
Yes.
Right, and I have moved, if we look to the right, the column that contains the green and blue text exchanged, I've moved forward in time. Specifically, what is depicted is the area or time, January 7th, 2023. Is that correct?
Yes.
All right. I want to first start with this text. It's dated January 7th, 2023, 7:44 and 13 seconds PM. You see the one I'm referencing?
I do. It appears to be a screenshot of a news article.
All right, and did you, upon review of this information, if material like a screenshot is shared, can you then retrieve or sort of look further at what items were sent via the message?
Yes, in that format right there, if you were to double click on essentially where that box is, it brings it up as a much larger photograph.
Okay, so the image, I'm sorry, the message that I'm referring to, who is the sender of this message?
Josh Reedy.
If I double click and open up the screenshot, what is Josh Reedy sending on January 7th at around 7:44 p.m.?
It's a screenshot from Channel 10 News in which it reads, "One man in critical condition following vehicle pedestrian crash in Lansing," and there's a photograph of police in the background.
And is this a screenshot of news coverage of this specific investigation that we're referring to?
Yes, it is.
In addition to screenshots, are there other forms of media that can be sent via Messenger or via this messaging through Facebook?
Yes, there are. There is also the capability to send voice messages like you would a voicemail to a cell phone number.
And so I am hovering over one of the messages. Is that correct?
You are.
All right, and who is the sender of this message?
Josh Reedy.
And what does the Facebook records indicate that he sent in this communication chat with Ms. Romero?
It's an audio file.
And similar to the screenshot, if we were to double click this audio file, would it play?
Yes.
Yep. Yeah. And just for the record, the one that I have here, this is on the date of January 7th, 2023, 7:47 and 27 seconds PM. Is that accurate?
Yes.
One who hit that fucking nigger.
I'm gonna move down to another message, January 7th, 2023, 7:48 PM, 7:48, 19 seconds PM. Is that correct?
It is.
Who is the sender of this message?
Josh Reedy.
And what did he send?
Another audio.
And this is still the same conversation with Ms. Romero.
It is.
On everything. Yes, I used Casey's car and I ran over a fucking nigger. He is in critical condition, but they took her to jail because witnesses seen that it was a female driver. Well, it was not a female driver. Obviously, it was me.
You reviewed that message, that audio message as part of your investigation?
I sure did.
You recognize the voice that's on that audio message?
I do. I listened to thousands of messages over the course of this investigation between he and others.
And when you say he and others, who are you referring to?
Josh Reedy and other people he communicated with.
You recognize that voice as Mr. Reedy?
Yes, I do.
In addition to the chats, was there other media saved or provided by Facebook that you viewed on the Cellbrite platform that has further associated that data with Mr. Reedy?
Yes.
For instance?
There's photographs
Of?
Mr. Reedy took of himself
So
on his Facebook, sent to others.
So what we would call selfies?
Correct.
Okay. And that, based on your investigation, further connected this Facebook data to Mr. Reedy?
It did.
In addition, I know I'm still on that last audio clip, the one January 7th, 2023, 7:48:19. Can those individual audio files be saved sort of externally outside of the Cellbrite platform and the Facebook data? If you know.
I don't know the answer to that.
Oh, no, I just did that because it's other things that it's supposed to show. Thank you. No further questions.
Cross-examination.
Morning, Detective. Or this afternoon, Detective. I want to go back to when you were reviewing video footage of what you alleged was the incident. Do you recall what I'm talking about here? You went to someone's house, they had video cameras out. Do you recall what we're seeing?
Yes.
Okay. Now, you indicated that you didn't actually see the footage of the, let me strike that. You watched video from someone's cell phone, correct?
I did.
And that cell phone captured what the video captured that evening, correct?
It's hard for me to answer that with a yes or no because
Okay.
it's a complex answer.
Okay.
So the person had Xfinity as their home security provider. Xfinity is an application that was on this person's phone. Through the Xfinity app on their phone, I was able to see the videos that were saved through their Xfinity cameras. Like as we just looked similarly through the message content. It was a list of videos with timestamps that their surveillance system picked up.
You were not able to preserve that information?
So typically in this scenario, an analyst would have preserved that data. However, that form was sent with an improper date on it. So that data directly from Xfinity was not able to be obtained.
Okay, so it had an improper date on the actual video stamp or the?
No, the
date stamp?
preservation letter that was sent to Xfinity had the improper date on it. So the date that was on that form was a date in 2018, therefore completely irrelevant. They don't have the data longer than 7 days. So once that error came to light, there was no way for me to go back and get the correct actual data from Xfinity. Too much time had passed at that point.
On January 7th, 2023, did you effectuate an arrest warrant that day?
An arrest warrant? Yes, I did.
And who did you arrest that day?
I did not arrest anyone. The person was already in custody at LPD's lockup.
But did you effectuate the warrant itself?
The warrant? Yes, I did.
And you indicated that when you first come to a case, you look over the general information, is that correct?
I did.
And you look at the interviews of suspects?
At that point, I looked at what.
You look at the different interviews, is that fair to say? You look at the different interviews that may have been conducted?
There hadn't been any interviews outside of on the scene.
All right. You look at the evidence that has been collected thus far?
Correct.
And you looked at all of that, correct?
I did.
I have no further questions this time. Thank you, Your Honor. Thank you.
Any redirect of Mr. Stevens?
None, Your Honor, thank you.
May this witness be excused?
Without objection from the people.
Any objection from the defense?
No. Thank you.
Without objection, witness, you're excused. Thank you for your appearance today. Any further proofs, Mr. Stevens?
Your Honor, people have asked.
Any proofs today from the defense?
No, nothing for the defense, thank you.
All right. Motion for bind over, Mr. Stevens?
Thank you, Your Honor. At this point, the people move to bind the defendant over as charged. As indicated on the felony complaint, the date of January 7, 2023, at or near the location of 1016 North Cedar. Mr. Reedy is charged in count 1 with assault with intent to murder, and count 2, assault with a dangerous weapon, specifically a vehicle, and count 3, failure to stop at the scene of an accident resulting in serious impairment or death. What we have laid out through the testimony of these witnesses is that on that specific date, in the early morning hours of January 7, 2023, the Lansing Police Department responded to 1016 North Cedar Street. North Cedar Street is, as depicted in People's One, in close proximity to the area of Adams Street and Center Street. In fact, Cedar and Center run north and south. Adams runs east and west. Officer Moore testified that upon arrival, he followed a trail of blood, essentially from the intersection of Center Street and Adams, all the way up one of the full city blocks, the city of Lansing, all the way up to the address of 1016 North Cedar, where ultimately he observed a few things. 1, the blue Chevrolet tracks, and 2, ultimately had contact with the defendant and another person identified as Ms. Erickson. From Officer Ellis's testimony, we saw and heard of the graphic injuries sustained by the victim in this matter, name identified as Jesse Lamont James. The body cam footage of People's Exhibit 2 captures in real time the anguish and pain of Mr. James. We see him sitting in a pool of blood that is ultimately depicted in People's Exhibit 3. Further, the Officer Ellis is able to confirm the identification of our suspected victim based on securing and identifying his Michigan identification card, which is depicted in People's Exhibit 4. Of course, of note, from both the body-worn footage of People's 2 and the photograph of Mr. James' identification card, this court can clearly see that Mr. Jesse Lamont James, just based on the photograph, is a male weighing approximately 180 pounds, standing 5 feet 11, and is a black male specifically. Of course, we have testimony from Officer Ellis that in addition to seeing it, he documented a particular item relevant to the investigation, that being in People's 5, the orange t-shirt of Mr. James that we see in People's 5, but we also see depicted in People's 2, the body-worn footage. From there, we move to Officer Sam Fearnow, the CSI officer who largely documented 2 important aspects in this case. In People's 6, 7, 8, and 9, we have the incredibly graphic and severe injuries that Mr. James sustained. I know the court saw them when I presented them and was walking through them initially with Officer Fearnow, so I don't think it's necessary to display them all again. From there, Officer Fearnow then had the responsibility of processing the blue Chevrolet tracks, license plate number ELP 9340. That was the same tracks or same vehicle that Officer Moore documented that he observed upon arriving at the scene, sorry. It's also the same vehicle that we know is associated with Casey Erickson. Of note, Officer Fearnow documented, as depicted in People's 12, a suspected blood spatter on the undercarriage or underneath side of this vehicle that tested it, at least presumptively, for the presence of blood. And then in People's 14, Officer Fearnow noted an orange fiber found connected to the undercarriage of the vehicle. Now, while I made sure to clearly ask Officer Fearnow that he was not saying that that orange fiber was necessarily the same, on behalf of the people, I think circumstantially, that same orange fiber directly links to what is depicted in People's 5, which is the orange T-shirt that we see Mr. James wearing when police arrive on scene. It is quite clear, based on the evidence, circumstantial and direct, that the body of Mr. James was found at the intersection of Adams and Center on January 7, 2023. A trail of blood leads from his body all the way to the address of 1016 North Cedar. That trail of blood and the physical evidence, specifically blood and fiber evidence, connect the blue Chevrolet Trax as a likely vehicle or method by which Mr. James sustained those injuries. The ultimate question then turns to who did that? And based on the investigation from Detective McGonigal, I think what speaks most clearly, what transcends most of this evidence, are the words of the defendant himself. The detective testified that she secured, as part of her investigation, social media evidence, particularly Facebook or Meta platforms data from Joshua Reedy. And upon review of that, she observed and listened to and reviewed chat conversation between Mr. Reedy, an individual name identified as Holly Romero. Based on the review of that, believed that those two individuals related, specifically Mr. Reedy identifying Ms. Romero as his sister. And as was played in court today, on January 7, 2023, the exact same day this event happened at 7:48 to 19 seconds, not even 24 hours later, Mr. Reedy sends a voice message identifiable to this detective as the voice of the defendant, Joshua Reedy, in which he says quite clearly, quite explicitly, yes, I used Casey's car and I ran over that effing N-word. Now, despite the graphic nature of that sentence, the word that is more deplorable than any other word, what is important from that sentence is a few things. Again, there's no one word that is more deplorable than that, but what he's referring to is, that is Mr. Reedy, is that he ran over a black male we know to be Mr. James. And what immediately precedes that is he says, yes, I used Casey's car. We know that that blue Chevrolet Trax, license plate ELP 9340 Peoples 10, was registered to Casey Erickson. After that, Mr. Reedy says in this audio statement, he's in critical condition, meaning that black male that he was referring to, which we know to be the case as to Mr. James, as testified to by the detective. But they took her to jail because witnesses said it was a female driving. And what Mr. Reedy is referring to is they took Ms. Erickson to jail, as we have learned on this record, that initially on scene, Ms. Erickson was arrested. Mr. Reedy concludes this this audio message to Holly Romero by saying, we know, well, it was not a female driver, obviously, it was me. So thanks to Mr. Reedy, we know, in fact, who sustained the injuries, caused the injuries to Mr. James. I'd let the record note that Mr. Reedy was nodding in agreement a moment ago. And so for the following reasons, I'd ask the court to bind the defendant over on all three charges as indicated on the felony complaint. Unless the court has any specific questions for me or would like me to present or demonstrate any of the additional exhibits, I have nothing further to say. Thank you.
Thank you. Defense response, Mr. Milks?
Thank you, Ron.
Thank you, I appreciate it. Your Honor, at this time, the defense would request this court dismiss the charges against my client for people's failure to present evidence to every element of the crime. Speaking specifically, Your Honor, to the assault with the intent to murder, there's been no evidence whatsoever, no evidence presented to this court regarding intent at the time of the offense. While this court may infer from the facts, Your Honor, intent, there's been no evidence here even to make that inference at this time. There's no distinguishment between intent versus accident at this juncture. To the contrary, there's been an indication that there was one set of tire tracks going forward on the road. It wasn't something where an individual backed up and tried to make several attempts in this situation. There's also no evidence here that my client and this individual even knew each other, no argument. There's been no motive presented here. Now, while motive is not necessary, it's very important because we're not seeing any sort of intent to commit serious or inflict serious bodily harm. Your Honor, this is not much different than a civil infraction causing serious bodily injury. And the people have not been able to distinguish between those two offenses in this matter. Obviously, there's been plenty of evidence regarding injury, and there has been plenty of evidence to inflame the passions of this court, but that's also going to be the intent of the jury, Your Honor. There's not going to be any evidence to support bind over in this matter regarding intent, and this court cannot infer intent based upon the evidence presented. Thank you, Your Honor.
Thank you. Any response to the objection to bind over?
Two things, as Mr. Milks indicated, this court can certainly infer intent. And I would point to two things. First, there was in fact testimony regarding an argument beforehand. Detective McGonigal indicated that she viewed surveillance footage from only 2 houses down, where she narrated a timeline, specifically between 2 male voices. I think her words was, the conversation was not pleasant. And that immediately preceded what she narrated as this vehicle leaving, backing out of the scene, out of the area. Mr. Milks indicates that this strikes as merely an accident. Frankly, dragging an individual underneath a car for that distance, leaving a trail of blood, leaving that bloodied individual on the roadway, doesn't strike or sit as an accident. It sits as very callous behavior. And frankly, that callousness carries over and is in full display when we review the defendant's own statements post-offense. So his post-offense statement, his post-offense conduct, yes, are incredibly inflammatory, but they're his words. And that callousness strikes this record, strikes the people, and frankly, probably strikes this court as an indication that the defendant had that intent, or certainly could be inferred that he had that intent. We didn't hear anything on the statement that he was sorry that he ran over that person. He simply acknowledged it and moved on and said it was him, and used language that, like I said, transcends all offensive conduct. And that callousness, I think, demonstrates very clearly the mental state of this defendant. And so for those reasons, and frankly, at a minimum, while Mr. Milks's argument is well placed, at a minimum, I think what has been created is a factual issue, the mental state of the defendant to be addressed and to be further decided by a jury. So with that, again, people renew their motion for binding.
Thank you. The court has had the opportunity to see and hear the witnesses. There were 4 witnesses, Officer Donovan Moore, Officer Jake Ellis, Officer Sam Fearnow, Detective Martha McGonigal. The court was also able to perceive 15 exhibits that were admitted into evidence. And so the court had the witnesses and exhibits. So as to the date, January 7th, 2023, the standard here is probable cause. The people must prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. The date as of actually January 7th, 2023 has been proven by probable cause evidence. The venue, City of Lansing, Ingham County, has been proven by probable cause evidence. The location of 1016 North Cedar Street is the house where the blue tracks ended up. It seems that the actual occurrence was Adams and Center which is right around the corner, right down the street. So that's been proven by probable cause evidence. Location, offense, location, venue, date. The identification of Mr. Reedy was done in court, and Mr. Reedy was identified for preliminary examinations. So that has been made by probable cause evidence. And then we get to the elements of the crime. So in regards to the elements of the crime, there's count one did make an assault upon Jesse Lamont James with the intent to do the crime of murder, that being a life offense. In regards to bind over, what it comes down to is who is behind the wheel of the car. And I think the investigation indicates that the blue tracks was driven by Joshua Paul Reedy on January 7th, 2023, the offense location of 1016 North Cedar Street. Defense counsel appropriately brings up that what the intent is what needs to be proved in regards to the assault with intent to murder. I find by probable cause evidence that the intent has been proven not only by the hitting of the individual with a motor vehicle of blue tracks, but also by the statements made by the defendant themselves as to the investigation of Detective McGonigal, who indicated on at least two occasions, but that he was responsible for the hitting of the African-American individual, and that he used it. The terms he used were ones used associated with callousness and assaultive behavior, not used by negligence or accident. So I find that by probable cause, the count one has been proven by probable cause. I find that count two, which is the lesser count, a felonious assault, did make an assault upon Jesse Lamont James with a dangerous weapon to hit a vehicle without intending to commit the crime of murder or inflict grave bodily harm, will carry over as to the lesser count as count two. I've already bound over on count one, which is the intent to murder, which would fulfill all the elements of count two. As to count three, which is a different count, a felony count, did being the driver of an automobile who knew or had reason to know that he had been involved in an accident upon 1016 North Cedar Street. Property open to travel by the public, did fail to immediately stop the vehicle at the scene of the accident and remain there until he or she had complied with the requirements, or report the accident to the nearest or the most convenient police agency or officer in order to comply with the requirements when there was a reasonable and honest belief that the remaining at the scene would result in further harm and the accident resulted in serious impairment of a body function of the death of Jesse Lamont James. We have over and over in 15 exhibits the fact that Jesse Lamont James, along with the video, had horrendous injuries in regards to this act, in regards to what the court has found by probable cause evidence was an intentional act, and remained at the scene. And we saw a body cam of the person coming onto the scene and seeing Mr. Lamont James in whatever recovery is possible after an event like that. I find that the elements of met to count three failed to stop it and an accident resulting in serious impairment or death. I find that those counts have been admitted. The elements of that crime have been dictated to and have been proven by a preliminary examination probable cause standard in regards to the witnesses and exhibits. So I will bind over the defendant as charged on counts 1, 2, and 3. So your time here in district court is done, Mr. Reedy. Any further date will be in circuit court. You get that information from Mr. Milks, your public defender. You're bound over on all counts today, and your next date will be in circuit court. Anything for the record in regards to file 23-00497, Mr. Stevens?
Nothing for the people, thank you.
Anything, Mr. Milks?
Before bind over, Your Honor, I guess it's addressing bond in a sense. My client does have and he's okayed me to share this with the court. My client does have a traumatic brain injury, Your Honor. And he does have a neurosurgeon who is at this time recommending that or not recommending, I think he needs some sort of brain surgery or something along those lines. I can't speak specifically to that, Your Honor. I guess we're asking to amend bond to allow him the opportunity to go to his doctor or see his doctor, or at least giving him that opportunity to do so, Your Honor, having an order signed so the jail will take him to the hospital as needed.
All right, I understand the nature of the motion. Any reduction or modification of bond can be held in circuit court. Quite frankly, the $150,000 cash surety is where the bond remains at this time. So the motion to amend or reduce is denied at this point in time. And you can, once there's some declaration of paperwork, you can bring it to that court's attention in circuit court. And that's left to the circuit court judge. At this time, bond remains the same. Anything else, Mr. Stevens?
Nothing from the people, thank you.
Anything else, Mr. Mills?
No, thank you, sir.
All right, thank you. That's all for the record in 2300497.
Thank you.
Thank you.
Other two.
Yeah.
Okay.
Were you planning on going forward on the other two today?
No.
Okay.
I figured you were gonna put them on the record, so
Right, I will. So let's go ahead and address the other two cases. We have docket 2300492 and 2300493. People of the state of Michigan versus Joshua Reedy. Mr. Stevens, your appearance for the record, and then we'll address these two files.
Andrew Stevens on behalf of people.
And good morning again, good afternoon, Your Honor. Stephen Milks on behalf of Mr. Reedy, who's present and seated to my right.
All right, and this is the time set for preliminary examination on two additional files, 492 and 493. Mr. Stevens, how are we proceeding?
Thank you, Your Honor. Today was the date and time scheduled for the preliminary examination. For those two other files, I would indicate to the court, I had Officer Robert Forbes, a subpoenaed witness, present when it became evident before starting the last preliminary examination that the complaining witnesses on the respective cases, they weren't going to be here. I informed Officer Forbes that he could leave and that ultimately these two cases would be dismissed because the people are unable to proceed on today's date. So with that, I believe Mr. Milks will have a motion as to those two files, and I have no additional comments.
All right. So at this time, the people are unable to proceed on the additional two files. Mr. Milks, do you have a motion?
Yes, Your Honor. At this time, as the people are unable to proceed and the defense is ready to proceed at this time, Your Honor, we ask that there be a dismissal in both files. Thank you, sir.
Thank you. All right. So in regards to docket 2300492 and 2300493, the people are unable to proceed. Defendant moves to dismiss. The court will dismiss both files without prejudice. Which for our terms, Mr. Reedy, means that both files are dismissed today without prejudice. The people could reissue if they choose to, but for our purposes today, both files are dismissed today. Anything else for the record in docket 2300492 or 493? Mr. Stevens. Mr. Milks, anything else?
Nothing from the defense. Thank you, sir.
All right, you're all set, Mr. Reedy. Thank you for your appearance today.
Can I just stand up for a moment? Yeah. Crazy. Something I'm just shaking. No paperwork or anything?
No, you should be good.
Yeah.
I
told Mark to leave him out of here.
Okay. Deep bound over his charge. And I signed it.
And you signed it?
And I signed it.
Yay, Judge. We have a few minutes before our next.
We have 40 minutes. Yeah. Nice job, gentlemen.
Sir, long day for you guys. You still
Yeah,
have more this afternoon, don't you?
Yeah, we've got some landlord tenant this afternoon, but but that was That was a good feeling.
Prosecutor. Yeah.
No, we like it that
You know,
way.
as kryptonite is, those minor chokes.
Oh.
That's
Is that what did it?
I think so.
That's fair.
Thank you for
You know, I had a
spelling
good
so
case
many words.
Up until you brought
Andrew.
those last two statements in.
Yeah. Well, yeah, because I'm doing it without a witness, so
Yeah, I'm just.
still in the hospital too. He got out and had to go back, yeah.
The no, I can.
Thank you for the spelling assistant, because I'm like, is there a name witness? I don't know.
Well, I just got into it with Elaine over at, I did the homicide over in 55th, and she was like, I need the spelling of the two witnesses. I'm like, I don't know, I don't remember any of this even coming up, so I had to make some phone calls. I'm like, who are these people? And so thankfully we were able to answer it. And I'm like, I need to do a better job of that.
Thank you. It's very helpful.
You saw they were gone.
Yeah.
They're around the corner. So.
Oh, okay.
He's a real pinch.
Bravo.
Something. He is something, I'll tell you that much.
Oh. What's up, Sean?
Been tasked with inventorying our printers.
There's only one in here.
Is this one?
Yep. Only that one. There's two in the office.
Got those.
There's only one in here. I don't even know where we ended up with the one that used to be in here. It's not here anymore because I kept kicking it. There is no room for me up here. Are you thinking?
Yes. Yes, where this is going in the future of this case.
Don't hurt yourself.
Oh, I won't. No, I.
All right, we have a little bit of time. Judge is gonna send an email so we can know what. Before we play with it.
Thanks for sticking around.
Where'd that go?
I don't know. I just figured I'd thank you anyways.
Thank you.
Both of you.
I disagree with that. I understand what you're saying. I disagree with that. Sorry, I don't have any.
Hey.
Welcome back.
So what short docket this
Yeah,
morning?
yeah.
I'm happy about that. Don't have a docket next week, next Monday. I didn't check.
I don't even know.
Because it's
I also didn't realize that this Friday is a
Easter
holiday.
Monday, yeah.
Yes.
Oh, believe me, I count my holidays. I know.
Yeah, it's a good thing.
That's people in the state of Michigan or the city of Lansing versus Madison Nicole Mowry. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Assistant City Attorney Amani Williams appearing on behalf of the city of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Mowry, who is standing to my right.
And ma'am, you are Madison Mowry?
Yes, Your Honor.
All right. This is the time set for probation violation hearing. Ms. Williams, how are we proceeding?
Your Honor, the city is not contesting the findings of the probation officer.
All right, so Ms. Sutter?
Thank you, Your Honor. We do not intend to run a contested hearing today. Ms. Mowry intends to plead to the violation. I would just ask to be heard regarding the recommendation.
All right, and you've had the opportunity to see the pink sheet recommendation that was given to the court by Ms. Bayless?
Yes, I've received the amended one file date of 3/29.
All right. Yep, that's the one I have. All right. So may I inquire your client of the allegations made on the probation violation?
Yes.
All right. So Ms. Mowry, you understand that this is the time set for a hearing in regards to couple probation violation allegations made against you. Do you understand that, ma'am?
Yes, Your
All
Honor.
right. It's my understanding it's your decision today to plead to plead responsible to those allegations. Is that correct?
Yes.
All right. So this is in regards to request and summons for probation violations. It's alleged that in a technical violation that you failed to refrain from alcohol as directed per Avenel on February 24th, 2023, and that you did test positive. Actually, that's the only one I have. Failed to refrain from alcohol as directed on 2024, tested positive. How do you admit to that?
Yes, Your Honor, I did.
All right. So that's a violation of probation. And the court finds that the violation of probation in regards to it was said knowingly, accurately made, and then we'll go right to probation violation recommendation. Ms. Williams, you've had the opportunity to see the recommendation?
Yes, Your Honor.
All right, Ms. Sutter, any allocution concerning the probation violation recommendation? And I will state for the record that that looked pretty fair to me.
Yes, Your Honor. I have spoken with Ms. Mowry about this. I also have been attached to this case for quite some time. I was the original attorney of record in the underlying file. I will say that Ms. Mowry, in my experience with her, has been a person who is trying quite hard to get through as best she can and comply. She does admit that she's disappointed in herself for this violation and freely admits to the violation, as well as talked to me about her hopes of continuing on forward without any further issues. I think it's clear to the court from this report just how close she is to being completed here. I will say, in terms of the overall picture of her probation, it was 6 months term of probation. My memory of her sentencing was that she was told to complete the MAD Victim Impact Panel. Ms. Bayless here has indicated that was done, and that as far as I'm aware, Ms. Mowry has attended every session that she is supposed to with the MAD Victim Impact Panel, as well as her PATS outpatient program. This is also her first and only violation, and it is a single violation. Now, obviously, testing positive for alcohol is not a great violation to commit, but it is her only violation in 6 months. And so specifically regarding Ms. Bayless's recommendation that probation be extended for 4 months, I think that's quite a hefty recommendation to almost double the length of her original probation term for a single violation, when in every other sense, Ms. Mowry has perfectly complied with the orders of probation and completed everything that she was supposed to in a timely manner. She's also up to date with payments, as far as I can tell. There's a balance to be continued paid off, but she is up to date with payments. So if the judge is going to consider, if Your Honor is going to consider this recommendation, I would ask that the majority of this be accepted, but that recommendation to extend 4 months be adjusted to something along the lines of perhaps a maximum extension of 1 month to allow further clean testing while completing any necessary requirements Ms. Mowry has on probation. Thank you.
Okay, and my understanding is the end of her probation date is April 18th. Is that correct?
That's correct, yes.
All right, Ms. Williams?
Your Honor, I would like to agree with the probation officer that the probation needs to be extended. If not for 4 more months, it could be at least for 2 more months, just to make sure that Ms. Mowry is complying with her probation terms and she's not going to fall off the wagon again and start drinking.
All right. I think 2 months extended probation is fair in this matter, to put it. So the end of the probation date would be June 18th, 2023. I do think that and so I'm gonna indicate that, I think that's, and so the 19th, all right. So it'll be, so 2 months, April 19th, 2023. I'm gonna keep testing the same. So testing stays 1 time a week. The defendant has completed the VIP since the violation. There was indication here to change to intensive outpatient. It appears that that was a part of the original order. Is that correct, Ms. Sutter?
Not intensive outpatient. She has been participating in outpatient treatment through PATS. Ms. Bayless is suggesting it be increased to inpatient or intensive outpatient. I would suggest I don't feel it's necessary. Again, she's been complying perfectly.
I'm good with just the continued outpatient. Continued outpatient. 2 months probation. I'm good with regular outpatient, not intensive outpatient, not IOP. I'm gonna indicate for the record, 7 days jail that's held in abeyance, all right? So you're not doing any more jail time, but essentially what it is kind of a tipping point here. Because I know till June, you're gonna be clean, all right? And and if you're not clean in June and you're caught, then we're looking at jail time. And you're really at the end of your probation. I mean, this is really it. And I've said it 100 times and I'll say it more. What you look at in this probation is, I just want to get this behind me so I can get on with my life, okay? I look at this as maybe 4 years from now, when you're not under probation, you'll decide to make better decisions. And we've already seen that this is only one violation in what really is pretty spotless in regards. So if it seems like I'm coming to the conclusion that you've been almost perfect, I kind of want you to be perfect, all right? I kind of want you, I kind of want to feel good that when you leave here, you know that months from now, you're going to make good decisions about this, all right? So that you and I don't have to have this conversation, and so you never get to see me again. I know that's pretty sad, but that's what we're hoping for, right? That you never get to see me again. So I'm going to extend to June 19th. That'll be June 19th. All else is to say the same. I'm going to indicate jail, but held in abeyance for 7 days, and then as a part, and then dismissed as a part of a successful probation. All right. Anything else for the record, Ms. Sutter, in docket 22-01692?
I have nothing further, Your Honor.
Anything, Ms. Williams?
No, Your Honor, thank you.
All right. Ms. Mari, good luck to you, okay?
Thank you.
All right. Thank you.
Thank you. No, good luck to you.
So between the sentencing sheet and that should be covered. And you said we're ready to go on Mr. Hanley?
Mr. Hanley is here and ready to go.
All right. So let's call to the record docket 20-03103. That's people of the state of Michigan versus Jeffrey Scott Hanley Jr. Will the parties please introduce themselves for the record?
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Hanley, who is standing to my right.
And sir, you are Jeffrey Hanley Jr.?
Yes.
Okay, this is the time set for sentencing. Ms. Williams, is there any restitution in this case?
No, Your Honor.
All right. As Ms. Sutter, have you had the opportunity to go over the pre-sentence report with Mr. Hanley?
I have.
Any additions, deletions, or corrections?
Not at this time.
All right. Allocution.
Yes, Your Honor, thank you. As the court might recall, this is a case that resulted from a protest being done in 2020. So there are, in my discussions with Mr. Hanley, some First Amendment concerns here, and he ultimately did choose to take responsibility for his decision to not perfectly comply with police instructions on the day of this incident. I will remind the court, there's an overall impression with a summarization of the agreement here. However, I think there's a correction to be made to that. The probation officer who prepared this report indicated there is a Kilgore agreement for a delayed sentence with 6 months term of probation. That is correct. At the time of plea, the court indicated that that 6 months was to start at that time. I reviewed that court hearing. That is what the court said. So just
So that was on January 23rd.
That's correct, yes. So that understanding of communications with the court at that time was that 6 month period of time was to start on the 23rd, which would, my math brings an additional maximum of 10 weeks additional. I would ask the court to consider a term of probation of 2 months, 8 weeks for Mr. Hanley. They are recommending that 20 hours of community service be completed as well as a moral recognition therapy. Your Honor, I would ask that the court consider the 20 hours of community service. I do think that's a fair recommendation here and doable within a 2 month period of time. However, I would ask the court to consider setting aside the recommendation for moral recognition therapy. I understand that is a valuable program for many people, especially in assault cases or cases involving alcohol or substances. However, that's not the case here. Mr. Hanley maybe wasn't perfectly compliant with the officers that day, but he was there protesting something that he felt morally very strong about, and he was with a large group of people who were acting kind of in concert. And so there were perhaps some decision-making failures there, but I don't know that I could or would call it a moral failing, considering that he was there for what he believed to be a moral and ethical purpose. And I think that's something that's fair and important for the court to kind of consider in this. He is wanting to take responsibility for any decisions made that day that weren't perfectly in line with the court, while still balancing them with what he feels to be his ethical, personal, and philosophical kind of guidelines. So I think a term of probation of 2 months with completing 20 hours of community service is giving back to the community and making right perhaps any community wrongs that were done here, and setting aside what, quite frankly, I don't know will do anyone any good, which is the moral recognition therapy in this program. Thank you.
Thank you. Ms. Williams, any comment?
Your Honor, the city leaves the sentencing to discussion of the court.
All right. Well, Mr. Hanley, I've had the opportunity to read the pre-sentence investigation and I agree for the most part with your lawyer. Okay. This is for the hinder oppose. This was for the protesting, which on some level our country was based on protest, as I see it. However, there also are consequences that come with such activity. And these are one of those consequences. You've always indicated that you understood that. And as long as we're willing to understand the consequences for our actions, then we understand that that's a part of protest. I have a very good friend who said, if you're not getting arrested at a protest, you're not doing it right. And there's a lot of truth to be said for that. He also said the same thing with the understanding that there are consequences that come with what I'm doing. And he understood that. And that's kind of where we stand. So I'm going to indicate, I think you have an understanding of what happened here. I mean, I'm not surprising you in any way. So I'm gonna adopt the recommendation that your counsel's indicated. I don't think moral recognition therapy is useful in this regard. I just don't find it useful. I think telling somebody what's moral and what's not is really subject to their own debate and how they feel as a person. But you understand that does have a place. I just don't think this is the place for it. Okay. I do believe that there are consequences that come with decisions we make, and therefore these consequences are they hinder oppose police and officer. It's a guilty to count 2, fines and costs at $100. So fines at $150, costs at $150, crime victims' rights at $75, state minimum cost of $50. Those are all things that those are crime victims' rights and state minimum costs. I don't have any say on that. That's a part of the legislature's response. I am finding you $125 fines and $150 fines and $150 cost for a grand total of $425. Probation, I think, is fair for 2 months since this started at your date of guilty at your plea. So that adds an extra $60. So I'll give you a grand total. It's $485. I'm going to put probation at 2 months, which started at date of guilty plea. What's that? Yes, I'm sorry. It should be 6 months, but started at date of guilty plea, which would make it two more months. That's fair.
From today.
Yeah, two more months as of today. 2 months as of today. 6 months as of January 23rd. Sometimes I think I write too much and then it gets confusing for them. I think 20 hours community service is warranted in this case. I'm not ordering moral recognition therapy. It says obtain and maintain employment. That's in your discretion. Okay, that's discretionary. You do have some fines and costs, so you probably want to pay those off rather than come see me.
And Your Honor, I would ask that he did post a bond himself of $100. I would ask that be applied.
Okay, so bond to be posted to fines and costs. Not purchase or possess any firearms in the next 2 months pursuant to the order. So that started January 23rd. Other than that, Mr. Hanley, I mean, protesting carries with it its own consequences. That's just the nature of it. Some judges understand that. Some judges are going to go by the letter of the law and they're going to pound at you on it. Okay. Understand that I'm somewhere in the middle, but I understand that you have a right under the First Amendment to say and indicate what you want to say, but you don't have a right to break the law. And there are consequences that come with that. All right. Anything else for the record in docket 20-03-103, Ms. Williams? Anything, Ms. Sutter?
Just to confirm, because I see a box check on here, the court is not ordering random PBTs, correct?
I'm not arguing. That's a good catch. So I am not ordering random PBTs.
Thank you. I have nothing further.
Random PBTs, and I am not ordering. And I'm not ordering no bars or nightclubs. I'm glad you caught that, because for the duration, no use of possession of alcohol, marijuana, or controlled substance without a prescription. But I'm not going to argue random PBTs, and I'm not going to order no bars or nightclubs as a part of this. Anything else, Ms. Sutter?
Nothing further.
All right, thank you. That's all set. You're all set, sir. Okay. All right.
I appreciate your perspective and also that of your friends.
Thank you. Yeah, that's all for the record in that file. Ms. James, are you ready on Ms. Way?
I am, Your Honor.
All right. So we're on the record in docket 20-03104-0M. The City of Lansing versus Lauren Lee Way. Will the parties please introduce themselves for the record?
Assistant City Attorney Amanda Williams appearing on behalf of the City of Lansing.
Attorney Gidget James appearing on behalf of Lauren Way, who was present at defense table and standing to my right.
All right. And ma'am, you are Lauren Lee Way?
Yes, sir.
All right. This is the time set for a sentence in the matter. Ms. Williams, is there any restitution in this case?
No, Your Honor.
All right. Ms. Ms. James, have you had the opportunity to go over the pre-sentence report with your client, Ms. Way?
We have reviewed it, Your Honor.
Okay, any additions, deletions, or corrections?
Not at this time, Your Honor.
Allocution.
Your Honor, as you know, Ms. Way is a co-defendant of Mr. Hanley. This is an incident where they were protesting together. In fact, they were in the vehicle together when the vehicle was stopped. The underlying facts are pretty much identical. I will be respectfully asking Your Honor to follow Mr. Hanley's recommendation or his sentence. Me and Ms. Sutton did speak in detail about that. We feel it's appropriate. Your Honor did state on the day of plea on January 23rd that their time would begin at that time and conduct themselves accordingly. She has done as such. I do agree with the court that there is something to come from protesting, but at the same time, and I've had this conversation several times with Ms. Way, it does not allow you to break the law. You still have to follow the law while doing it. It comes with its own consequences, as Your Honor has said, and she does acknowledge that. I believe it's even in the body of the report that she acknowledges she knew what she was doing. She's a regular protester, and she is aware of the consequences. For that, Your Honor, I would ask the court to sentence Ms. Way to 2 months probation. The only difference is her recommendation does recommend the MRT. It does not recommend community service. I don't think that the MRT would be beneficial because she knew what she was doing and is aware of the consequences, does this regularly. I think it would be far more beneficial for her to do the community service and give back. With that being said, I ask Your Honor to follow Mr. Hanley's recommendations and probation sentence. And I would like to say also, she is gainfully employed full-time, Your Honor, and expecting a promotion very soon.
All right, thank you, Ms. James. Ms. Williams, anything, any comment?
No, Your Honor, we leave sentencing to the discretion of the court.
All right, Ms. Way, you've seen the sentence before you, and Ms. James has spoken on your behalf. Do you have anything you'd like to say to the court before the court passes sentence?
Simply would like to apologize and take accountability for my actions.
All right. All right, thank you. You heard my take on this type of case.
Yes.
And maybe I have a little different take than other judges in regards to some of this. And the hardest part of taking part in a protest, something that I think it should be done and should be done knowing there's consequences, is that you never know what judge you're going to get. So that's the truth, or you never know what prosecutor you're going to get. And so you kind of know my take on this. You kind of go into it expecting the worst case scenario. I don't see anything that you did in regards to assaultive behavior, anything like that. What I saw is you made up your mind to protest a point, and you did so because you believe you have the right to protest the point. I couldn't agree with you more. It's just when others believe that you violated the law, and then we get to the point, that's where consequences come in. And so I'm somewhere in the middle, but with the understanding that this is not. I sat through a prelim this morning where somebody committed an assault murder. It's a very, very different type of case. Okay, and I see the difference. All right. So with that understanding, I'm going to fashion a sentence which is exactly like the person that Mr. Hanley, who you're with. So your 6-month probation starts January 23rd. So you'll have 2 months from today's date, which will be, what did we say, June 19th?
That'll be June 5th.
June 5th. Okay. So 2 more months probation for on June 5th. What's that? So is that a 7th? The 5th. Okay. So I am going to order, so this is for the hinder and post police officer. I'm going to order $150 fine, $150 cost, crime victims' rights fee of $75, state minimum cost of $50. So that's 300 plus 125 is the 425. 2 months probation is going to be for $30 each. So I'll add $60 to that. So that's a grand total of $485. Let's make that 60 to make sure. All right. So the probation is for 6 months, but it started as of January 23rd. No assault or threatening behavior, no use of possession of alcohol, marijuana, or controlled substance without a prescription. I'm going to strike the random PBTs. I'm gonna strike no bars or nightclubs. I am going to, you're gainfully employed, so I'm not gonna worry about that. I'm gonna strike the moral recognition therapy. And I'm gonna issue in that stead 20 hours of community service, which you're probably doing already on some level.
Yes,
So,
sir.
so 20 hours of community service in light of the moral recognition, the MRT course. No possession of firearms, ammunition, or weapons of any kind under this term of probation. So that'll be until June 5th. And anything else for the record in docket 20-03104, Ms. Williams?
No, Your Honor, thank you.
Anything else, Ms. James, concerning this file?
No, Your Honor, thank you.
Ms. Way, good luck to you, okay?
May I actually ask one question?
Sure.
With the community services, am I allowed to choose where I do?
They're probably going to assign it to you, but you can always make recommendations as long as it fits in. Ms. Sutter probably knows a little bit about that.
Yes, there is like a 5-page list of pre-approved locations that probation provides to people.
Right.
schools,
So they'll give you a
libraries.
list and then you can choose from there.
Wonderful.
All right. Thank you. All right, we're all set on that file.
Yeah, you can do that. They'll accept those and listen to them, but they do have like a long list of pre-approved places.
Did I sign that one?
If it was, I don't think it is, but just because it's not, doesn't mean we're gonna say no. I could say, okay,
You know that means you, yes.
I started, they'll investigate
trying
if
to-
it's placed
since
there
the
or
judge
not.
was
They're kind of messy. You're probably the right for that. Awesome.
Thank you so much.
Thanks. Would you just go up the marks on that side? Yeah. Thanks.
Is this Mr. Beasley?
It is.
All right,
We are ready to go, Your Honor.
all right. So we're on the record in docket 23-00026. That's people, the city of Lansing versus Davion D. Beasley. Will the parties please introduce themselves for the record?
Assistant City Attorney Emmanuel Williams appearing on behalf of the City of Lansing.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Beasley, who is standing to my right.
And sir, you are Davion Daryl Beasley. All right. This is the time set for a sentencing today. Ms. Williams, how are we proceeding?
Your Honor, the city leaves sentencing for the discussion of the court.
All right, that was almost out of habit. I did that. Is there any restitution on this case?
No, Your Honor.
All right. Ms. Sutter, have you had the opportunity to go over the pre-sentence report with Mr. Beasley?
I have.
Any deletions, additions, or corrections?
No firm corrections at this time. Within employment, he is still currently unemployed, though actively applying, in particular to Walmart.
Okay. All right. Allocution, Ms. Sutter.
Thank you, Your Honor. This is another young man with whom I've spent a lot of time talking about this case and his life with. He's been actively involved in his own representation here, which I think is always to a person's credit rather than forcing me to take the bulk of it. He has been actively involved in how best to move forward with his own case. And that continues with this recommendation. I've reviewed it with him and he has no issues with it. He's happy to comply and forge forward with the recommendations of probation, that being the moral recognition therapy program and the 20 hours of community service. I think the 20 hours is fair to complete in a period of time, and he's quite happy to find a program that probation is happy with and give back to his community in that way. In regards to the fines and costs, Your Honor, I would ask that it be kept at a minimum. This is a young man who is currently unemployed. He is applying, but for right now, his financial situation is quite difficult for him. He does have a lot of active family involvement. His mother has been very, very involved in his case, and that is always, I think, to a person's benefit. But he is responsible for his own bills here, and he's a little bit struggling right now. So I would ask the court to keep that in consideration. Thank you.
Thank you. All right, so this is in regards to a sentence on count 2, guilty plea, furnish false information to an officer. Ms. Williams, I'm sorry. Did you have any comment you wanted to make as to sentencing?
No, Your Honor, no comments.
Mr. Beasley, anything you'd like to say to the court before the court passes sentence? All right, thank you. So this is for the filing of false information. I will indicate I find the judgment of sentence to be fair. I think that probationary terms are fair. So I'm going to follow the recommendation. So I'm gonna give you credit for the 1 day in jail that you spent. And credit is given for 1 day previously served. I'm gonna suspend any other jail time as a condition of probation, all right? I'm gonna waive fines and costs in this matter. I'm gonna indicate that crime victims' rights fee is $75. State minimum cost fee is $50. Probation is 9 months for a grand total of 270 plus 50 plus 75, $395. So probation is set for 9 months. It's $30 a month per probation. So that's where the $270 comes from. I agree that you should perform 20 hours of community service within the 6-month period. No assaultive, threatening behavior, no use of possession of alcohol. Submit to random PBTs and or urinalysis as directed. That's really because of the nature of the type of crime involved. No bars or nightclubs.
Your Honor, I apologize.
Yes.
My understanding is there's no alcohol involved in the underlying case here, so I would ask the PBTs in your analysis testing be removed as well.
I don't remember the nature of it was start out as a 2-count complaint.
I believe you gave a false name to the officers. I do not know that alcohol or substances.
I don't see any indication of alcohol in this. So I'm going to strike random PBTs. Yeah. And I'm gonna strike no bars or nightclubs. Sir, I've got so you are 22, right? How old are you, sir?
21.
21, all right. I'm gonna strike no bars or nightclubs. You're still under order not to drink, okay? All right. I'm gonna order the moral recognition therapy as a part of the therapy in this. No possession of firearms, ammunition, or weapons of any kind. So really adopted the recommendation, except as to the random PBTs and no bars or nightclubs are struck. Also, the recommendation stands. I've waived fines and costs. And so you understand your total is $395 to be paid over the course of your probation. You understand that, sir? All right. Anything else for the record in docket 23-00026, Ms. Williams?
No, Your Honor.
Ms.
Thank you.
Sutter.
No, Your Honor, thank you.
All right. That's it. You're all set, Mr. Beasley. Good luck to you, okay? Okay.
Yeah, it's gonna be divided by 9. You not pay the amount every month. Your first payment starts a month from now. If you want to, feel free. If you can make any additional payments, you can. You just have to pay a minimum every month. If you want the extra, get it on your way. Go for it. All I do too, if I could. My recommendation, give it a couple minutes and then head down to the commission now. Check in with them, get yourself on the register. Just go down 1 floor to the probation department instead of just a sentence. I'm here to just check in with the commission. So yeah, for you. You're all set. Any questions? Call me.
Thank you. Let's call Miss Barden before the landlord tenant docket starts coming in. You're all set? You're all set, Miss Sutter?
I believe so, Your Honor.
All right, thank you.
Thank you.
And so we're on the record in docket 21-01515. I'm gonna let everybody in here just in case on Zoom.
Hello?
Ma'am, can you identify yourself for the record on the cell phone?
Yes, Marilenia Rodriguez.
Is it Miss Rodriguez?
Yes,
You're here for your 215.
yes.
All right, thank you. All right, I'm going to call to the record docket 2101515. That's City of Lansing versus Laura Barden. I do not see Miss Barden in the Zoom courtroom. I do not see her in the physical courtroom. This is the time set for a probation violation arraignment. This was scheduled for 1:30. It is now 2:16. I will state for the record that part of the reason why we're having a probation violation arraignment is because probation has lost touch with Miss Barden because they can't find her, and that's why we're here. So it would appear that she is not present in the courtroom. She has failed to appear today, and I'll issue a bench warrant and bond forfeiture for her failure to appear. So that's all for the record in docket 2101515. Yes. Got that?
Thank you.
Yep. And ma'am, on the cell phone B131DL, will you please identify yourself?
Kenyatta Holloman?
You might have to say that again. I missed that.
Kenyatta Holloman.
Holloman. All right, you're here for your 2 o'clock, Kenyatta?
Yes, sir.
All right, is Kalisha Holloman with you?
I'm here.
All right. All right, stand by. You're in the right place. And I'll let you know. I just saw Mr. Lum was here. So I'll let you know when we're ready. You're in the right place today.
Okay, thank you.
Miss Gordon, what case are you here on, ma'am?
I was just informed to be here during this time period because I was under the impression that there were some eviction cases during this time period. Is there none
There
scheduled?
are.
Okay.
We have hearings set starting at 2 o'clock, landlord-tenant hearings. So you're more than welcome to be in the courtroom. I was just making sure I understood who was in the Zoom courtroom.
Of course, yes. I am here for the Advent House Housing Stability Program.
All right, perfect. All right. All right. So you're in the right place, and we should start our hearings in a few minutes.
Awesome. Thank you.
Thank you. All right, Ms. Holloman, I think your attorney may be in another courtroom, the attorney on the other side. So just stand by and we'll wait to see when that attorney joins us, all right?
Okay, yes, sir.
All right, thank you.
You're welcome. I hell with this. It's a summons. docket room. Excuse me. Right, can you move the heights around, you can put a chair. Want me to move that chair that way? Okay. Okay, we got his own case. His own case right now. I'm trying to see you. I gotta watch too short. I see you. Mine's too short. I'm seeing, is it like the same as my phone? Is it the same as my phone? Yes. It's longer. I would say it's a long cord. I don't know. I see it's like. Ouch. I go home. Shit, let's go stay. You might take the phone with me because I didn't come call it. Ooh. I can't hold it. Come on. Phone just went out.
All right, so we're on the record. You might have to set them up or
He's in the breakout room. They need to join the breakout room.
Mr. Lum's right there with the iPad.
I know, he's in the breakout
Oh,
room.
okay.
They need to join the breakout room.
Oh, do they need to go in the breakout room?
Their screen's frozen.
Their screen is frozen. They're in the breakout room. All right. So we're on the record in docket 22-03735. Will the parties please introduce themselves for the record?
Yes, good afternoon, Your Honor. Attorney Chris Brown representing plaintiff.
And ma'am, you are Marilena Rodriguez?
Yes, sir.
All right. This is the time set for a formal hearing in the matter. Mr. Brown, I'm in possession of a consent and order for conditional dismissal. So how are we proceeding today?
Yes, Your Honor. I've gone over the actual numbers. Ms. Rodriguez is in agreement that the rent that's now due and owing through the end of the month of April is $3,000 total, is including court cost, is $3,615.40. We've set her up on a payment plan to pay that amount of money. She is going to start paying in $500 increments, $500 to be paid starting on, with the first payment starting on April the 14th, Friday, April the 14th, and then $500 continuing every Friday thereafter until paid in full. Thank you.
So I'll indicate C, conditional dismissal for plan. It is a payment plan that has been set up. You did indicate it was a $3,615.40, and it's I have through the time period ending 4/30/2023. Is that correct?
That's correct.
And Ms. Rodriguez, that's your understanding of the language of the conditional dismissal?
Yes.
All right. Is there anything that was discussed on the record that you had not talked about with Mr. Brown in the breakout room?
No.
All right. And my understanding of the conditions of the plan is that you're to pay $500 per week starting Friday, April 14th. Is that correct?
Yes, sir.
All right. So I have the conditional dismissal with me, and to that effect, with those numbers and that plan, and I will sign that.
Thank you, Your Honor. And she did give me permission to sign on her behalf, which I did.
All right. Anything else for the record in docket 2203-735, Mr. Brown?
Nothing, Your Honor. Thank you.
All right, Ms. Rodriguez, any questions of me today?
No, Your Honor. Well, just one more. I wouldn't. It's going to be dismissed as long as I continue making the payments, and I wouldn't have another court date, right?
Correct. This will be dismissed as long as you stick to the plan and you're paying $500 per week starting on Friday, April 14th.
Perfect. Thank you. I just wanted to make sure I didn't have
All
to
right.
appear
Thank
again.
you, ma'am. All right. That's all for the
Bye-bye.
record in docket 2203-735. Thank you for your appearance today, Ms. Rodriguez. You're free to leave the Zoom courtroom. Always a pleasure, Mr. Brown.
Thank you, Your Honor.
Thank you. Bye-bye.
We'll just hold on to Harper's.
And see you next week.
Okay. Yeah.
I think so.
Mr. Lum is.
Oh, you're back here.
Oh. So leave. Okay.
All right, so Ms. Holloman, you're back. Oh, where are you going?
Mr. Love, we have Ms. Hoffman back.
I wasn't able to understand her very well.
Maybe she's back here. Maybe she just readmitted herself.
We had talked about doing an adjournment for her.
Yeah. She needs to, well, she's supposed to be here in person.
Yeah.
And she's not. And obviously this technology is not working to that regard. All right, ma'am.
Yes.
So you are Kenyatta Holloman, correct?
Yes, sir.
All right, and you had the opportunity to speak with Mr. Lum in a breakout room?
Yes, sir.
All right, my understanding was that there was some technological difficulties in regard to that. There certainly was with you leaving the room and then coming back, right?
Yes, my phone. I hit the wrong button. I had to turn back my phone back. I had kind of died, so I had to push my my battery saver on.
All right, and you understand that at our last pretrial on February 1st, we indicated, and I've got it in my notes here, and that this was supposed to be a live hearing. That today's date was supposed to be a live hearing. Do you understand that?
Uh-huh.
You're not live, you're on Zoom. Yeah, live like in person live.
Oh, I see. And I thought it was supposed to be Zoom, like on the Zoom. I didn't know it was
right.
person. I my apologies, sir.
No, well, I think my understanding is that it may be better if we adjourn the date to get a live date here in person so that everybody can talk and we don't have technological issues. So I'm going to call to the record docket 22-03487. That is Arbors at Georgetown versus Satyad. I'm sorry. No. Yep. Edgewood Villas Limited versus Kenyatta Holloman and Kalisha Holloman. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Brian Lim on behalf of the plaintiff.
And ma'am, you are Kenyatta Holloman, correct?
Yes, and it's Kalisha Holloman.
And this is Kalisha Holloman. All right.
Yes.
This time set for a formal hearing. Mr. Lum, how are we proceeding?
We've discussed with the defendant an adjournment.
Okay.
For an in-person hearing.
Okay. All parties appeared. I think it would work best, Ms. Holloman, if we adjourn this for an in-person hearing so that everybody's here in the courtroom and we can go forward if necessary, either taking testimony or resolving the matter. But I do think that this is probably a better set for a live hearing. And when I say live, I mean in person on the 6th floor and the city of Lansing, okay?
Yes, sir.
All right, so I'm going to set aside a formal hearing that all parties appeared. We adjourned for live in-person hearing. And we should probably maybe put aside make sure that it's some time for testimony. So let me find a hearing date.
We have civil jury on April 12th. It doesn't look like a whole lot.
We'll try like at 1:30 or,
No, we have hearing.
all right.
You wanna try like a 10?
Yeah. So we try April
12 at 10.
April 12th at 10 a.m.
Okay,
Does that work with your schedule, Mr. Lum?
I have a number of trials that morning. From 9 till 11. Are those with you or no?
I don't, those are, is April 12th is what?
It's a Wednesday.
It's a Wednesday. Those might, they could be with any one of us. You'll be here.
Yeah, I'll be here.
They're not with us? Okay. So they're probably with one of the other judges here.
Yeah, I mean, I'll be down here. What time did you say?
10 a.m. Let's try it April 12th at 10 a.m. So we'll set it for April 12th at 10 a.m. All right, Ms. Holloman, you should be here in person, okay?
yes, sir. What floor?
On the 6th floor of the City Hall building, yourself and Kalisha should be here on the 6th floor at 10 a.m. And then
Yes, sir.
we will go either resolve this or take testimony. All right, ma'am?
Thank you, sir.
All right, that's all for the record, docket 22-03487.
Thank you. Write it down. April 12th. That's next up.
All right, and Ms. Holloman, you're free to leave the Zoom courtroom.
Okay, thank you. I know that I can't work for a day.
Ms. Gordon, we have 2 files left and we're waiting on 1 till 3 in order to see if the tenant appears. Just so you're aware of what we're doing.
Thank you, Your Honor.
And we have another one that we're just holding on to because neither party's appeared. So we'll call both of those at 3.
Understood. Thank you.
So we're on the record in docket 2203-550. That's, make sure I got this right. Clark Brothers Capital versus Isaiah Little. Will the parties please introduce themselves for the record?
G. Jack Burke, standing in for attorney of record Kevin Sutherland, representing the plaintiff, Your Honor.
All right. And this is the time is set for a formal hearing. It would appear this was initially scheduled for 2:45. It is now 3:24. I will state for the record that we initially had a pretrial in this matter that the defendant failed to appear. There was service by attachment, so we set it for the second formal hearing for today's date. It would appear the defendants failed to appear once again. Mr. Burke, how would you like to proceed?
I'd like to proceed with a possession judgment, Your Honor, and I believe a proposed judgment has already been submitted to the court.
All right, so default judgment is orally granted, and I will wait for the written order to sign. Order to sign. Anything else for the record, docket 2203-550, Mr. Burke?
Not from the plaintiff.
All right, thank you. You're all set. That was easy enough, huh?
Yeah, once we made it into the court. So if we've already filed the proposed order electronically, will that make?
It'll probably make it to me if not by this afternoon, tomorrow.
Okay.
So.
And then would you like me to fill out?
A default?
Yeah.
Yeah, go ahead and fill it out and then make sure that the civil department has it. And that they can make sure it's given to me, right? That the civil? Yeah. Yeah.
Okay, I'll
All right.
give it to the civil clerk.
All right.
Thank you very much.
Thank you.
for your time.
And then we're on the record docket 2203-236. That is Arbors at Georgetown versus Satyadra Wheeler.
Oh, I do have a dismissal for that.
You do?
It's sent to our report review email, not civil.
Oh. And it appears that case was dismissed. So that's all for the record. Docket 2203-236, a dismissal was sent in. So that's all for the record.